required to leave?
We do last call at 2:45. All customers have to be out by 3. No exceptions. That's the law.
And if all customers were out by 3, what time would you have gone out, like left?
If that incident occurred at 4:30, I would have had to have left about 3:55 that morning. Because I was in my subdivision and within a half a mile of my own house.
As far as the parking lot is concerned, how wide, how large is the parking lot of the Gold?
Objection, relevance.
Your Honor, I'm going to ask that question because I'm going to next ask her, did she pay any attention to whether or not anyone was on the perimeter of it, or did she even see that?
Your Honor, she's already testified that there was no one there at the time she leave.
I object to
No
the
exception.
speaking.
Okay, all right, okay. I'm going to sustain the objection. Just move on, all right?
Sure. And you said that you left and you got in the car, you didn't notice anything, but was there anything on the perimeter of the parking lot? Anything at all that caught your attention, or nothing at all?
I really don't pay attention. I mean, when I walk out, I notice like the manager's car, security is usually there, a foreman, cars of any young ladies who have not been able to pass the breathalyzer. They leave their cars because we do have overnight security. As far as the perimeter, behind us is a trailer park. If you're exiting our club, to the left would be a trailer park. Directly in front is a liquor store, and to the right is Metropolitan. So as far as the parking lots where the liquor store and everything is, I wouldn't have paid attention because there, again, can be cars in and out across the road. There's parking, and there are cars there throughout the night, and when we leave in the morning sometimes. So I would have paid that no attention either.
Now, I asked you whether or not you knew a Trontavious Stevens. Are you at all familiar with, or have you ever had any reason to be at 2612 Old Hateville Road?
No, I don't know where Hateville Road is.
Okay, thank you. That's all that I have. Defense may have some questions.
Cross.
Yes, ma'am.
Mr. Adams.
Yes, sir. Ross, good morning, man.
Good morning. How are
You
you?
okay?
I'm blessed, thank you.
All right. You and I have not met before, true?
That is a true statement.
All right. And so I want to ask you just a couple questions.
Yes, sir.
And I know that this case we've been discussing, the incident which you happened back in 2013, right?
That is correct.
10 years ago, roughly.
Yes.
But I want to ask you about this case. All right? Some questions about this case that you're here for today. So, you were a house mom back in 2013, right?
That is correct.
This incident you've been questioned about occurred in Newnan, Georgia, where you live.
That is correct.
That location is about a half an hour or so away, maybe a little bit more, from where you were.
That is correct.
When you left the club that night and you went to Newnan, you drove to Newnan, you did not notice anyone following you, anything like that.
No, sir.
One of the things you testified to a little while ago, correct me if I'm wrong, and if I say anything wrong, please correct me, all right? You said that the customers are gone by the time you leave the location.
That is correct.
They're cleared out. I think your words were no exception, right?
That is correct, yes, sir.
So when in talking to the officers later on in regards to that incident, nothing to suggest that there was anyone, you didn't see anyone following you when you left the club, right?
I would not have been aware of anyone, no, sir.
All right. In fact, the first time that you noticed anything, according to the police report that Madam Prosecutor showed you a little while ago, was when you were actually in Newnan, close to your home, correct?
Correct.
You saw lights in your rear view, and you actually, it kind of caught your attention because you thought, hey, I'm driving slow, and you thought the person behind you, the lights coming up on you might be kind of irritated that you were driving slow. You remember telling the police that?
I really do not even remember that part of it,
Okay.
and I apologize. But if I told him that, then I'm certain, and that does sound like something I would say.
Okay, and listen, no need to apologize, we're just asking what you remember, to try to get a sense of what's relevant.
Objection, Your Honor, as to relevance.
I sustain the objection.
Thank you.
All right, rephrase, sir.
Oh, yes, sir. All right, so back to the facts of what happened. Someone hit you from the back,
Yes, sir.
you get out of the car,
Yes.
you see a young man, kind of nondescript looking young man, right?
Correct.
5'7"-ish,
Yes, sir.
130-ish pounds, a small guy,
Yes, sir.
maybe a little smaller than me.
Probably a little smaller. Yes, sir.
Give me 5'8".
I look, I don't want to hurt you. I'm trying not to step on your toes on that one, okay?
And I appreciate that too. But this kid gets out of the car.
Yes, sir.
And he says something to you on the effects of you say hello, and he said yes ma'am, or something like that, all right?
He greeted me. I don't remember if he said hello ma'am or how are you. He greeted me. I greeted him. He greeted me in return.
You're in the back looking at your car, and he in the meantime goes around, jumps in your car, and takes off.
He circles up on the curb and, yes, sir, he turns around and takes off back out the direction in which we had come in.
You don't know where that kid in the car he was in came from, right?
Oh, correct, no.
I mean, this is Newman, so, whether, this kid came from Newman or from wherever, you don't know. The only thing you know is that this happened about 35 or 40 minutes away from where you work in Atlanta, right?
That is correct, yes, sir.
You didn't recognize this kid coming out of the car, did you?
No, sir.
Okay. You cannot say, hey, look, I saw him before. That face looks familiar. Not at all.
No.
Okay. Your car is going at that point, and you ultimately end up talking to the police. True?
True.
Okay. You speak to the police, and you told them what happened. You told them about the car having OnStar, and about 6 days later is when you're notified, whether by the police or someone, that the car had been recovered or found. True?
True.
Okay. You don't know, right? I mean, frankly, what happened to the car in that 6-day period of time, right?
That is correct, no, sir, I do not.
You have no way of knowing. You can't testify that it went through 1 pair of hands, 5 pair of hands, 6 people went to however many different cities. We just don't know, right?
That's true, yes, sir.
All we know is that at some point the car was found somewhere in Atlanta, right?
Correct.
Okay. You were never called upon. I know you were asked this a little bit earlier. You were never called upon to come and identify anyone who was found in possession of the car, right?
That is correct, yes, sir.
You were never told by anyone, by police, law enforcement, that anyone was found in possession of the car.
At some point, I received a call. They had found my car. It actually was sometime later. I was given 2 names because they did ask me if I knew the names. I wrote the names down and did not recognize the names. So that is the extent of it.
Right. And certainly there was never a time when the police said, hey, you know what? I want you to come in here and take a look at this picture and see if you identify anyone. That never happened.
No, sir, that did not happen.
All right. One of the things that you were asked about a little bit earlier, I only got a couple more questions for you because just a few more questions. Friday is when this happened, like Thursday going into Friday, right?
Right.
And what I heard you say earlier is that that day was like any other day, correct?
Oh, yes, sir.
It was kind of slow. Didn't appear to be anything unusual going on in the club.
Right.
When you are there at work, think your words were, I'm not that visible. You're kind of in the back. You're not really out there mingling with folks. Folks don't really see you, right?
No, they do not. That is correct.
To use your words, no one ever knows you're there.
But most of them do not. I really come in at 8, and like I said earlier, I might go back out on the floor one time. I often have to go to the office once for something. Shortly after getting there, I can't give you a time frame, within an hour after getting there probably. But after that, I do not go back out on the floor, no, sir.
Okay. And there was nothing, in this case, on this particular day, go to work, you're there, right?
Yes, sir.
Nothing really happens. Nothing out of the ordinary, right?
Correct.
You don't see anyone looking at you.
Oh, no, sir.
You don't see anyone walking out or walking around the perimeter of this location when you're leaving, because everyone's gone, right?
That is correct.
You get in your car, and something happens down in Newnan, Georgia.
That is correct.
All right. And that's it.
Yes, sir.
Oh, yeah. Thank you, ma'am.
Any redirect, madam?
I don't know any other.
Oh, I'm sorry. Any other examination? Ms. Sharp?
No, Your Honor.
All right, Mr. Williams?
No, Your Honor.
Mr. Matthews?
No questions, Your Honor.
All right, Mr. Weinstein?
No, Your Honor.
Mr. Swan? No, Your Honor.
Ms. Westmoreland? All right. I think that's it then. Okay, all
I
right.
have a great regret. Ms. Rosser, just a couple of questions following up from Mr. Adams. Mr. Adams mentioned where you worked in Atlanta, and I neglected to ask you when you said 2608 Metropolitan Parkway. That is in Atlanta in Fulton County. Is that right?
Yes, ma'am. That is the address to the Gold Rush.
And you said you did not know and had not visited 2612 Old Hayville Road. Do you have any idea how far 2608 Metropolitan Highway is from Old Hayville Road in general?
I have no idea.
Okay. And finally, you said when you were asked on cross-examination by Mr. Adams, no one knows that you're there. Is that sort of a generality, or is that literally you're meaning nobody knows that you're there?
It's a generality. I mean, the young ladies know I'm there. The regulars know I'm there. But, so, no one, being a universal modifier is not actually appropriate. People know I'm there, but most of the customer base, many would not know I was there.
Thank you, Ms. Ross. That's all I have.
You're welcome.
Anything further, counsels?
No, sir.
All right. May Ms. Rosser be permanently or temporarily excused the witness?
Yes, Your Honor. Thank you.
Permanent?
Permanent.
All right.
Thank you, sir.
Ms. Rosser, I'm going to permanently excuse you as a witness. I appreciate your patience with us. Don't discuss your testimony with anybody except the attorneys in this case, okay?
Thank you
All
very
right.
much.
Thank you, madam. All right. Ladies and gentlemen, how you doing? We good?
Yes, sir.
Okay. All right. Call your next witness.
They called Captain Pettis. There was a request regarding cameras.
All right. Members of the media, would it be appropriate, or could I ask your assistance in not filming? You may do audio or video, audio of our next witness, but the court would ask that you not film him, okay? All right. Thank you very much. Appreciate it. Okay. Can we summon Captain Pettis or Officer Pettis? Ms. Love, what's the first name of your witness, or Ms. Hilton, what's the first name of your witness, please?
To the court here.
Reginald?
Yes.
Thank you. Captain Pettis, good morning, sir. Sir, I'm up here. If you could please approach the witness stand. Once you get there, if you'd be so kind and turn and face Sergeant Ingram and be sworn as a witness before you sit down, sir.
Raise your right hand. You swear affirm testimony you give the truth, the whole truth, nothing but the truth.
I do.
Have a seat. State and spell your first and last name for me.
First name is Reginald, Reginald. The last name is Pettis, Pettis.
Good morning, Captain Pettis.
Good morning.
How are you?
I'm doing well, thank you.
Captain Pettis, would you please introduce yourself to the jury and tell them where it is that you currently work?
Good morning. I'm Captain Reginald Pettis. I am assigned to Zone 3 of the Atlanta Police Department.
And Captain Pettis, I'm surprised I don't have to tell you this, but I'm gonna need you to talk up a little bit louder.
Okay.
Because I can barely hear you back here.
All right.
The jury's be able to hear you. So you're assigned to Zone 3?
Yes, ma'am.
All right. Would you tell the jury what area of Atlanta Zone 3 encompasses?
Southeast Atlanta.
And you can look at them, talk to them.
Okay.
Southeast Atlanta, the border of Zone 3.
The rough border would be south of I-20, west of Moreland Avenue, and east of Murphy Avenue, with the southmost border being 285.
How long have you been the captain of that zone?
Since May 24th, 2022.
Now, prior to May 24th, 2022, and at this time, are you currently certified as a law enforcement officer by the Police Officer Standards and Training Council of Georgia?
Yes.
And how long have you been so certified?
17 years.
So prior to working or being promoted, I suppose, to captain of Zone 3, what was your position there?
I was the unit commander of our Homeland Security unit.
Now, would you tell the jury what responsibilities that you currently hold as captain of that zone?
I'm the assistant zone commander, meaning that the major is the zone commander. I handle most of the day-to-day operations and the staffing of the zone.
And what did you do as unit commander of the Homeland Security unit?
I oversaw a unit that consists of intelligence analysts, investigators, and technical investigators that have proficiency in all things computer related.
And how many investigators how many persons were you responsible for overseeing?
Approximately 12, including 2 sergeants.
Approximately how many?
12.
How long did you work as unit commander of the Homeland Security?
For about 2.5 years.
Where were you positioned when you were unit commander? Were you working in the same place, Zone 3?
No, ma'am. We were in the headquarters building, 226 Peachtree.
And before that, where did you work?
I was in the Auto Crimes Enforcement Unit.
How long did you work there?
About 6 months.
And from what date to what date were you in the Auto Crimes Enforcement unit?
Approximately January of 2020 until May of 2020.
Before that, what were your responsibilities?
As the ACE unit commander of the Auto Crimes Enforcement Unit, we were a traffic unit mainly, and our goal was to stop people from stealing cars, and once they stole cars, to interdict them and arrest those people.
What's interdict?
Figure out who they are, where they're going next, just gather intelligence on them. And then at the tail end of my tenure there, we really were being tasked with a lot of street racer enforcement because it was 2020 and everybody was in the house and that's what they were doing.
Those are the times.
Yeah.
Prior to January of 2020, what did you do with the Atlanta Police Department?
I got promoted to lieutenant in January of 2019. I was assigned to Zone 2 as the day watch commander. Then I got moved to the administrative unit commander in Zone 2, and then to the criminal investigations division of Zone 2.
And what were your responsibilities with the criminal investigations division of Zone 2?
Well, back then we had our investigators assigned to each zone, as opposed to now where they're all collected together at headquarters. So I supervised the investigations that took place in Zone 2.
Prior to January 2019, where did you work?
I was a sergeant. I was assigned to Zone 5.
Are you ready for a taste of Wisconsin?
July of 2014.
And before then, what were you assigned to do?
Before that, I was an investigator assigned to Zone 3.
Is Old Hateville Road in Zone 3?
Yes.
Specifically is 20... Six 12 Old Hateville Road in Zone 3.
Yes.
And is 2608 Metropolitan Parkway in Zone 3?
Yes.
Do you have any idea approximately how far apart those two addresses are?
No, ma'am, not without looking at a map.
Okay, come back to that. So you were an investigator in Zone 3 in January of 2013?
I believe so.
Right. You said before you became a sergeant in Zone 5 in 2014 that you were an investigator in Zone 3.
And before that, an officer in Zone 3.
Okay. Tell me when you started working as an officer and when you started working as an investigator.
I got to Zone 3 approximately July of 2010. I worked as an officer in Zone 3 until I got promoted to an investigator in Zone 3, which was the end of January of 2013.
Okay. Tell the jury a little bit about the responsibilities and duties you had as an officer in Zone 3.
As an officer, your main priorities are responding to 911 calls. Secondarily, you are to interdict crime, and you can do that in a variety of ways. Usually officers utilize the traffic stop and the suspicious person stop. We also perform what we call directed patrols, which is an area that is known to be a high crime area. So officers might pull into the parking lot there, turn their blue lights on, and complete their paperwork there. So we do response to 911 calls, proactive work, and deterrence efforts to prevent crime.
Were you always working in uniform during your time in Zone 3 in 2013?
No.
And on what occasion would you have to not be in uniform?
When I was assigned to the crime suppression unit, we would split the unit between uniformed officers and officers that were in plainclothes. The latter part of my tenure, I was assigned to the plainclothes part of that unit. We would perform various tasks in plain clothes. Some of them would be related to narcotics activity. Some of them would be related to general crimes or what crime was trending that week and what area it was trending in. So a lot of time we would act as the eyes and then call in uniformed officers to make stops.
Now, do you recall January 25th, 2013?
Yes.
Specifically as it relates to an incident that occurred at 2612 Old Hazel Road. What were you working on that day?
I was.
And in what capacity were you working?
I was working in a plainclothes capacity, driving an unmarked civilian vehicle.
Now, what was it that took your attention to 2612 Old Hazel Road?
We received information from our dispatcher that OnStar was tracking a vehicle that was taken in a carjacking, and it was in the general vicinity of Zone 3. And one of the beat officers let us know that he located the vehicle, and it was parked at this apartment complex.
Okay. And so, how long after you got that notification to do anything, like respond?
My partner and I got to the apartment complex parking lot maybe 10, 15 minutes later.
Okay.
We located the vehicle, and we parked in a position that we could keep our eyes on it in case somebody came back to the vehicle.
I'm going to show you what has already been admitted as evidence and marked as State's Exhibits 4A and 5A, and ask you if you recall whether or not those photographs depict the vehicle that you were calling in to look for.
They do.
So what do you do as you get into the complex to respond to this call?
After parking to keep eyes on the vehicle, to see who returned to it, it's pretty much a waiting game at that point. We hadn't determined yet how long we were going to wait to see if somebody came to the vehicle. I think it took about 45 minutes before we saw the vehicle drive past us. So we had initially not seen who entered the vehicle and drove it away, but the apartment complex is constructed in a way that the parking lot is like a big circle. So the vehicle came back past us and reversed into its parking spot that it previously occupied.
Okay. How far away from you was the parking spot where the vehicle backed into?
I don't recall, but we were close enough that we could make out a general description of the driver.
What was the general description of the driver?
Black male with black clothing and a do-rag.
Okay. What kind of do-rag?
I believe it was black in color.
Okay. What did that person do once they pulled in?
Well, I drove closer to the vehicle to get a better description of the driver and to try to see what apartment they were walking into. So as I did that, the driver turned and looked at us, so we were made at that point, most likely. So we saw the driver.
I'm going to object to this person being made.
Basis?
Speculation.
I'm going to overrule the objection, sir, at this point in time.
Go ahead, please.
So we saw the driver walk into the building, and then a short time later, several other people exited the building.
What, if any, apartment or building or unit did they walk out of? Do you know?
I believe it is apartment number 7.
And at this point, how far away from the vehicle that you were surveilling were you seated?
Approximately 10 feet.
What happened after that?
After the driver entered the building, several other males exited. They looked at my partner and myself in our vehicle, and they began motioning for us to roll our window down. They were shouting obscenities while doing so.
Now, what were the ethnicities or races of the other persons who came out of the building?
Black males.
Do you remember any general description of the persons who were yelling obscenities?
It would just be that they were probably all under 25 years old or around that age.
And what, do you know why they were yelling obscenities?
Objection, false speculation.
I sustain the objection.
I would draw that because you don't know what's in their head, but what obscenities were they yelling at you?
I did not roll the window down to the best of my recollection. There were some middle fingers. There were some gang signs being thrown. I cannot tell you what they were,
Okay.
but it was aggression was the general gist of it.
All right. So what did you do upon showing of this aggression?
At first, I did nothing, and then one of the males, who was the most I would say violent with his hand signals, his signs being thrown, and his motioning for me to roll down the window, lifted his waistband to show us that he had a pistol in his pants.
And what did he do at that point?
He pulled the pistol from his pants and held it down beneath his waistline while pointing the barrel at myself and my partner.
What did you do at that point?
I drove away. I drove toward the front of the apartment complex, and then we communicated with our uniformed officers that we call a takedown team that we needed assistance.
What happened at that point?
We circled around the parking lot because we saw the suspect who pointed the gun at us run away from the parking lot. I believe that he ran the opposite direction from the street, so we're traveling one way toward the street and he's running the other way. We drove around the apartment complex, as I explained before. It's set up like a circle or a U, and we saw him coming back in to the apartment complex through a hole in the fence. So he'd already made it outside of the fence and he was coming back in.
When you all saw him coming back in, what happened?
There was another vehicle that was traveling around the U. He flagged that vehicle down and then jumped in through the front passenger seat.
Then what happened?
The vehicle drove back out of the complex. By that time, one of our marked units had made it into the area, and the suspect exited the vehicle. The vehicle just stopped in the middle of the roadway, and the suspect got out of the front passenger seat and began walking away from the vehicle. And at that time, the two uniformed officers who were in the takedown vehicle were able to take him into custody.
Were there any items collected that had been discarded by that person?
Yes, we called in the assistance of a K-9 officer. It was from a railroad police department, might have been CSX, I'm sure it's in the report. And myself and my partner searched the wooded area where we saw the suspect re-enter the apartment complex. The K-9 was able to find a firearm that had been placed inside of a bucket.
And was that firearm the same description as the one that the person had pulled out after showing you the violent gains or hand signs?
Yes, ma'am, I was able to identify it as the same weapon.
I'm going to show you what has been marked as State's Exhibit 2 Alpha and 3 Alpha. As defense does not need to take any look at it, I'll show it to you and ask you if you recognize 2A and 3A.
I recognize them as being the gun that was on scene at the time.
Okay. Are those fair and accurate reflections of the firearm that you collected?
Yes.
Your Honor, the state tenders 2A and 3A as evidence.
Any objection to 2A or 3A? Mr. Adams or anybody else?
On behalf of the board.
Anybody else?
No, Your Honor.
All right. 2A and 3A are admitted and may be published as you see fit.
Thank you, Your Honor. I'm holding up 2A and 3A for the jury. Captain Pettis, let me back up to the time that you said that you saw the vehicle back into the parking lot before the gentleman got out and went inside. Was this gentleman, did you do or say anything to that gentleman?
No.
And how long would you estimate it was from the time that he went inside to the time that the group of people came outside?
Less than a minute.
And did a group of people come directly towards you, or were they doing something else and then noticed you?
I think that the
Objection to speculation.
Sustaining this to form.
What did you observe?
I observed them come out of the building with their attention already focused
Where?
on the vehicle that I was driving, myself and my partner.
Okay.
And then they immediately began throwing the gang signs and yelling at us.
Had you done anything to that group of gentlemen before they came out, focusing on you and your partner, throwing the gang signs and yelling at you?
No, ma'am.
Now, when you talk about gang signs, how long have you worked overall in law enforcement?
17 years.
And what, if any, training or experience have you had during that time that would give you the ability to recognize what a gang sign is?
We certainly had a block of instruction in the academy. In field training, we would be taught to look for those signs from our field training officers, pointing out the signs. But we would literally drive down the street and gang members would throw gang signs at the police car. Throughout my years, I've attended various other trainings that show gang indicators, from tagging to dress to words being said, certainly the colors, and hand signs being the most fluid and evolving indicator of a criminal street gang.
And how were you able to discern, a gang sign from just the middle finger?
I think it would be in the forming of the hands, and it doesn't look like a middle finger. It's more complex than that.
All right. I'm going to show you what has been marked as State's Exhibit 6 Alpha, 7 Alpha, 8 Alpha, and 9 Alpha as it relates to this particular incident. And also, let me ask, before I do show you these, 2612 Old Hayfield Road, that's in Fulton County?
Yes.
All right. I'm showing you, and given that this has been already served upon offense, I'm showing you 6A, 7A, 8A, and 9A. Would you look at those without publishing to the jury? And let me know if you recognize those photographs, the person in the picture.
I do not.
Okay. Do you, at the time that this incident occurred, are you the one that photographed anyone who had been arrested?
No, ma'am.
Okay. Who was it that did that?
I don't know for certain.
Was it a crime scene tape? That's what I'm asking.
No, ma'am. I think that it was one of our supervisors who responded to the scene.
Okay.
They usually kept the one camera that we had for the
Okay.
entire zone.
All right. And how did the supervisor or how did you all document or associate photographs with a particular incident?
It's usually done right there.
I'm gonna object. If he doesn't know, he's speculating.
Your Honor.
He's
I'll
speculating.
sustain this.
She's literally answering.
I'll sustain it. It's the form of the question.
Okay.
I'll sustain the objections to that. You can rephrase it, madam.
Sure. When photographs are taken during the course of an incident that you are involved in, is there a way that the photographs are associated with the incident itself?
The answer is yes. I'm trying to figure out the best way to say it. So
Okay.
let me think about it for a second.
Okay.
In most cases, the photographs are associated with the incident that's occurring by way of the officer or the investigator that is on scene.
Okay. And are those photographs associated with the incident number in the record keeping
Objection as deleted.
of,
I'll sustain it as to form.
is there an incident number associated with the photographs?
Yes.
Is that incident number and those photographs stored in the normal course of business with the Atlanta Police Department?
Yes.
Now, who is it that was arrested as a result of this incident that took place with you?
The suspect's name is Mr. Trontavious Stevens.
All right. And were there any other persons who were arrested on that day?
Objection, relevant.
Yeah.
I'll overrule the objection.
I believe that there was one other person arrested, but it was for a warrant, not a crime that had occurred that day.
And so the arrest that you made or that was made that day, what was that arrest for as it relates to what you were looking at?
Mr. Trontavious Stevens was charged with aggravated assault, and he also had an outstanding arrest warrant. I believe it was out of East Point for aggravated assault.
Okay. Do you know what Mr. Trontavious Stevens' arrest warrant out of East Point for aggravated assault, who that related to?
No, ma'am.
Was the other person who was arrested, what was that other person's name? Do you recall?
No, ma'am.
Was showing you a copy of your incident report refresh your recollection?
Yes.
All right. I'm going to show you what we have labeled as State's Exhibit 50 Alpha, the narrative provided to defense and discovery. Would you just take a look at page 15 at the bottom? Just read it to yourself and do not read it out loud. Just look up when you've had a chance to read it.
Okay.
Who is that person?
Mr. Desmond Hurst.
Now, was Mr. Hurst with Mr. Stevens when all of this happened?
No.
Okay. Where was Mr. Hurst?
Mr. Hurst was inside of apartment 7.
All right. And how was Mr. Hurst found?
Object as to relevance, Your Honor.
I'll allow it, Mr. Adams.
How was Mr. Hurst found?
The Zone 3 Crime Suppression Unit obtained a search warrant for apartment 7. The objective of the search warrant was to try to locate the vehicle keys of the stolen vehicle, of the carjacked vehicle. And during that search warrant, I've already forgotten his name. The other arrestee,
Mr. Hurst?
Mr. Hurst, thank you, was arrested because he was inside of the apartment and showed to have an arrest warrant.
Okay. Now, the vehicle you described, Mr. Stevens, as getting into, what kind of car was that?
Objection, mischaracterization of testimony.
I'll let you rephrase. I'll sustain it as a form.
When you spoke about Mr. Steve, or better yet, when you spoke about the guy that flashed a gun at you, walking up to the front of the complex and getting in a car, what kind of car did you get into?
I think it was a Buick.
Okay. Was there a traffic stop made on the Buick by Georgia State Patrol?
Yes.
As a result of what happened?
Yes.
Okay. And where was that traffic stop made on the Buick?
Not far, at a gas station on Cleveland Avenue. The apartment complex that's on Old Hateville is maybe a couple hundred yards away from Cleveland Avenue.
What gas station?
I believe it was a BP.
What was the address of the BP?
It was in the 100 block of Cleveland Avenue.
If I show you your report, will it refresh your recollection as to the exact address of the BP?
Yes.
All right. Showing you again, State's Exhibit 50A, asking you to look at the third paragraph from the bottom. And just don't read it out loud. Just read it and tell me if that refreshes your recollection.
Yes.
All right. Please tell the jury what the address of that BP gas station that the traffic stop was made by you again.
The address was 151 Cleveland Avenue.
151 Cleveland Avenue?
Yes.
And who were the occupants of that vehicle? Do you recall?
No, ma'am.
All right. Would showing you the report refresh your memory?
Yes.
And showing you the narrative, asking you to look at that same paragraph.
Okay.
Don't read it out loud. Just look at it and put it down and tell me if it refreshes.
Okay.
And I'll just leave that there for you to refer to if you need. All right. So who were the occupants of that vehicle?
Mr. Stovall and Miss Latrice.
Were those Jarrell Stovall and Shawanda
Objection to the
Latrice?
reading.
I sustain the objection.
Do you recall their first names?
Yes.
Please tell the jury their first names. And if you have to refer to the document to refresh your memory, let us know that that's happening.
Okay. I'm referring to the document.
Don't read it, but you have to look up and tell me.
Okay. Mr. Jarrell Stovall and Miss Shawanda Latrice
All right.
were their names.
Now, when police went to apartment 7 of the complex, were there other persons inside?
Yes.
Besides the one that was taken into custody?
Yes.
Do you recall who those other persons were?
No, ma'am. I'd have to refer to the document.
All right. Would you refer to the document? Don't read it. Look up when you've had a chance to refresh your memory.
Okay.
Who are the other persons inside?
Alfonso Dixon, Trevez Watkins.
Watkins?
No, I have to look again. Johnson,
Okay,
and the aforementioned Mr. Hurst.
all right. What were the races or ethnicities of these young men?
Black males.
All right. Now, were the occupants of the Buick any of the people that had come out of apartment number 7?
No, ma'am.
Were the people that came out, including Mr. Stevens, did you indicate in your report whether they had come out of apartment number 7?
I did not indicate that.
Now, when you said that you looked at the occupants of the Buick and decided they had not come out of number 7, do you recall what you said in your report about the occupants of apartment number 7 as it relates to walking towards your vehicle?
No, I do not.
Would reading your report refresh your memory? And if it would not, you have to tell me so that we can take another step.
I don't think it would.
All right. The report that I have in front of me that is marked as State Exhibit 50A. Would you look at it, not for the sake of refreshing your memory, but look at it and tell me if you recognize the report, first of all.
I do recognize the report.
How do you recognize the report?
It looks like the one that I wrote on January 25th, 2013.
Okay. Now, the report that you wrote on January 24th,
5th.
of 2013,
Yes, ma'am.
was that written in close proximity temporally to the time that the incident occurred?
Yes.
And is it a routine part of your responsibilities and your practice to memorialize incidents as they occur?
Yes.
And does the report that you memorialize, the incidents that you write a record of, do they accurately inside your report reflect the incidents that took place in close proximity temporally to the report?
Yes.
All right. And are these reports made during the normal course of business with the Atlanta Police Department?
Yes.
And was this report made based on the personal knowledge you had at the time that the incident occurred?
Yes.
Your Honor, under 24-803, past recollection recorded, the state tenders State's Exhibit 50A, Alpha.
Any objection to States 50A?
One moment,
Mr. Adams.
one moment, please. No objection to its admission at this point, does not go out to the jury.
All right, States 50A is admitted.
Thank you, Your Honor. Captain Pettis, would you please read paragraph, the third paragraph from the bottom in its entirety, starting with several?
Yes, ma'am.
Here.
Several Georgia State Patrol officers performed a traffic stop on the Buick in the parking lot of the BP gas station located at 151 Cleveland Avenue and detained its occupants. Mr. Jarrell Stovall, 04-12-82, and Ms. Shawanda Latrice, 07-25-91. This detention was necessary to confirm or dispel whether or not these occupants were involved in the carjacking. Officer J. Brown and Sergeant T. Henninger, 2397, knocked on the door of apartment number 7. After knocking several times, the door was eventually opened. There were 3 males inside, and they all were detained. Those males were Mr. Travis Johnson, 11-04-85, Mr. Desmond Hurst, 07-17-95, and Mr. Alfonso Dixon, 08-26-91. Officers M. Johns and K. Collins relocated with Mr. Stevens back to the apartment complex. Officer Ramirez and I then did a drive-by viewing of the occupants of the Buick and determined that they were none of the people that came out of apartment number 7 and walked toward our vehicle. They were
Right there. When writing, they were none of the people that came out of apartment number 7 and walked towards your vehicle. Who were you referring to?
the occupants of the Buick.
No. You said they were none of the people. The occupants were.
She's testifying at this point, but she's stuck with his answer.
Your Honor, there's no stuff with the answer.
Hold on. I will sustain that objection. So, Ms. Love, you do have to go through the proper foundation.
Sure, Your Honor.
You just can't tell the witness no.
I'm not trying to tell them.
Oh, yeah, well, you just started to, so that's why you drew an objection.
All right.
All right.
So, Captain Pettis, let me make sure I understand. When reading that last sentence, when you said none of the people, they were none of the people, who were you referring to when you said they were none of the people?
Can I refer to the report?
Yes, please.
The people that I'm referring to are Mr. Jarrell Stovall and Ms. Shawanda Latrice.
Now, if you would, please go up to the third paragraph. Actually, you know what? Start at the top and read the first 3 paragraphs.
Your Honor, I'm going to object.
Your Honor, it's an
Let him finish his objection first, madam. Okay, what's your base for your objection?
It's going to be cumulative. He's already testified. It's going to be improper bolstering. He's already testified about the items that she's asking.
I sustain it as to the
Your Honor,
second
I did
basis.
not. There's a particular part that he has not testified about. I'm certain Mr. Adams is aware of it. And
Well, I'm going to sustain the question as formed as of yet. You can rephrase if you like.
All right. Starting at the top of paragraph 3, would you read what you wrote there in paragraph 3?
I witnessed a black male, approximately 25 years old, wearing all black clothing with a black do-rag and black hat, reverse the vehicle into its parking spot and then exit and walk toward apartment number 7. By this time, I had driven my undercover vehicle to within 10 feet of the target vehicle so that I could observe where the driver was going. The driver stopped walking and looked at me. Several other males then exited apartment number 7 and walked down to the street level. The males were yelling at me and motioning for me to roll down my window. One of the males, later identified as Mr. Trontavia Stevens, was more aggressive than the other males in trying to get me to roll down my window.
Thank you.
You're welcome.
Now, do you recall the serial number of the firearm?
No, ma'am.
All right. Would you please read the next to the last paragraph of the narrative of your report?
Officer Ramirez and I then met Norfolk Southern Railroad Police Officer J.S. Shirley and his K9 Smoke near the hole in the fence that Mr. Stevens used. Smoke tracked toward a plastic bucket approximately 30 feet inside the wood line, which contained the pistol that Mr. Stevens pointed at me. The pistol is a black Beretta .380 caliber semi-automatic pistol, serial number D as in David 79, S as in Sam 62, Y as in Yankee. The pistol was turned over on scene to Atlanta Crime Scene Tech number 7345 to be processed.
Your Honor, at this time, the state having made state's exhibit number 10A as in Alpha, I'm going to have investigator Chief Long show it to Sergeant.
Does anybody wish to examine the State's 10? Or have you seen it?
Okay, second.
Okay, all right.
Thank you, Judge.
Okay. All right. Has the weapon been rendered safe? It has?
It has.
Sergeant Ingram? Okay, all right.
Would you take a look at 10A and tell us if that is the firearm that Mr. Stevens had? Look at it, pick it up, and look at the serial number, please.
Yes, ma'am. It matches the serial number.
And does it also match the,
Description, yes, it does.
and so is 10A the black Beretta 380 caliber semi-automatic pistol you described in your report?
It is.
State tenders 10A as evidence.
Any objection to State's 10? Anybody else? Anybody else have any further objection? All right, State's 10 is admitted. May be published as you see fit.
Captain Pettis, what was the age of Trontavia Stevens at the time that this incident took place? And if you don't remember, I'm going to ask you to read it from the report that has already been admitted as evidence.
Okay.
And the date of birth would be listed.
Per the report, Mr. Stevens was born on April 26, 1993.
And what date did this incident take place once more?
January 25th, 2013.
Thank you so much. That's all that I have for now.
All right, cross, Mr. Adams?
Please.
All right, go right ahead, sir. Oh, yes, sir. Go ahead right ahead. I'm sorry.
Thank you. Captain Pettis, good afternoon, sir. How are you?
Good afternoon. I'm doing well. Thank you.
All right. You and I have had a chance to chat before. Sure?
Yes.
All right. So, I represent Mr. Williams, the CEO of the Black Turtleneck, along with Mr. Steve. But I do want to ask you some questions about this gentleman that you arrested, Mr. Trontavious Stevens, and the incident surrounding him. Okay?
Okay.
You were an APD officer back in 2013, yes?
Yes.
You arrived at the location that we've been discussing at about 4:30 in the afternoon. True?
If that's what the report says, yes.
And I know we've spent some time with the report.
Yeah,
in front of you?
I do not.
All right. Matt?
Yes. Just please identify for the record, please. What?
Thank you, Judge.
Okay.
Judge, I'm going to, with the court's permission, approach the witness and show him what's been previously identified as states 50 Alpha 50A.
Okay, it's been admitted, so yes, that's fine.
All right, thank you, Judge. That's your report, right, Captain?
Yes, sir.
That's the report you prepared back in January of 2013, right?
Yes, that's right.
What's that, about 15 pages long, that report?
The report itself is actually only 2 pages. What's attached here is the warrant application, another copy of the report, and the actual warrants, along with the copies of the arrest tickets.
All right, the report itself that you wrote, about 2 pages, right?
Yes, sir.
But it fairly and accurately captures what happened on that day and your involvement in everything that happened. Is that true?
Yes.
Okay. Just to be clear, you were not involved and you don't know anything personally about how this vehicle that you saw came to be taken, right?
Correct.
I mean, you were aware at some point that this is something that happened over immunity, right?
I would have to look at the report to tell you what jurisdiction it was stolen from.
Because you don't know personally.
Correct.
And then you don't know where the car was, who was in possession of it, or how it came to end up in this apartment complex where you saw it, right?
Yes.
You don't know who, Trontavious Stevens, anybody else, was ever in possession of that vehicle prior to the day that you showed up in that apartment complex. Is that true?
Yes.
Okay. Now, I want to jump ahead a little bit and then come back. Because what I want to make sure I'm clear on is that what you actually ended up arresting Trontavious Stevens for was aggravated assault, right?
That was one of the charges.
What was the other charge?
The other one was pointing or aiming a pistol at another, and the last was the warrant that he had.
Okay. Essentially, what you, the officer who was involved, who was the crux of this case, what you charged it.
Objection, Your Honor, as to the testimony about crux of the case that Mr.
What's your objection, madam? Is it form? Is it what is
Foreman
it?
testifying.
I'll sustain as to form. Just rephrase, Mr. Adams. Okay, all right.
You were the officer who took out the charge, right?
Yes.
You are the person that's listed as the victim in this case, right?
Yes.
And the criminal offense that you charged Mr. Trontavious Stevens with was aggravated assault, right?
Yes.
You didn't charge him with auto theft, right?
Correct.
Didn't charge him with carjacking, right?
Correct.
Because you had no evidence that he did any criminal act other than what you said was an aggravated assault, right?
Correct.
Okay. In fact, what happened here, and I'm going to jump back now, is that you get to the apartment complex because you advised over radio that a stolen vehicle is located in this area, right?
Yes.
Okay. You get there, you are in plain clothes.
Yes.
You don't have a uniform on, you're dressed regularly.
Correct.
Your partner, Officer Ramirez, also in plain clothes.
Correct.
Dressed regularly, no uniform, nothing like that.
Right.
You're all in an unmarked car, right?
Yes.
No police markings on the car, nothing that identifies it as a police car, right?
Correct.
Anyone looking at the vehicle would see a regular car with 2 regular-looking folks inside the car, right?
Yes.
Okay. You pull up, and the car that we're talking about is parked there in location, and you guys sit on it.
Correct.
About 45 minutes.
Yes.
At some point, you'll know what happened to it because you saw it coming back.
Ghirardelli chocolate chips. Makes baking a bite better.
Okay. Comes back and it backs into a parking spot.
Yes.
Okay. A person gets out of that car, and that person starts to walk towards apartment number 7 that you referenced, right?
Yes.
Now, that person, from your observation, you're inside the car, and your windows are rolled up, right?
Yeah. Yes.
And you move towards where the car had backed in. True?
Yes.
Right. You're now 10 feet away from this car, maybe from here to about there, right?
Yes. Yes. 10 feet.
Windows still rolled up, plainclothes inside the car, and some people come out from apartment number 7.
Yes.
All right. Now, Trontavia Stevens, the person that we're talking about, who ends up, the person with the gun, the guy you arrested, he is not the same person who had gotten out of that car.
Correct.
In fact, at no point in this day did you see him interact with that car at all.
Correct.
Right. What you saw was him and other people coming towards your unmarked police car with the windows rolled up, with regular dressed individuals inside, and you saw them motioning to roll down the window, right?
Right.
And you said they appeared to be aggressive.
Yes.
In fact, one of the words you used is that, I think you said, Trontavia Stevens appeared to be the most violent in his actions, right?
Yes.
Now, when you testified a while ago for the state, and they asked you a couple questions about this, you said they were flashing gang signs, right?
Correct.
Right. Now, you didn't say that in your report, though, did you?
No.
And I mean, you wrote a 2-page report, and it was very detailed about everything that happened and everyone who was involved, down to names and dates of births, right?
Right.
You even put a serial number in there, right?
Yes.
And you're trained as a police officer that anything that is of significance, like if you think, for example, something is gang-related, you put that in the report, right?
Right.
But that report, the same one that she had you read, right, because you can remember some stuff, in that 3rd paragraph where it talks about what you saw those people doing, you ain't say nothing about, I saw gang signs, right?
Correct.
What you said was that the person who would later be identified as Trontavia Stevens, and again, I'll represent that kid, but what you said is that he was moving towards your car, right?
Right.
Motioning to roll the window down, right?
Right.
And then, and you never did. You didn't roll the window down.
I don't think so.
Okay. Was the window tinted?
I don't know.
You remember?
No, sir.
All right. You saw him motion towards his waistband, or grab a gun that was in his waistband. That's what you said, right?
Yeah.
And held it down like below his waist and pointed at you and your partner.
Correct.
Kind of like this, all right?
Yes.
That is the element of the aggravated assault that you saw and that you ultimately charged him with.
Yes.
You drove off at that point.
Yes.
Right, wasn't any shooting or anything like that. You drove off and you called for either backup or what do you call it, a takedown team?
Yes.
Okay. All right. So that was the crime, the ag assault, right?
Correct.
Police show up, takedown team, or one other car, a bunch of cars.
I don't remember the exact amount.
Would it be fair to say that within a relatively short period of time, there were cops crawling all over that location?
I don't think that would be a fair assessment. No,
Okay.
sir.
APD showed up, right? Other APD officers showed up, right?
Yes.
At some point, Georgia State Patrol was involved in this incident, correct?
Yes.
At some point, Norfolk State, Norfolk Railroad Police were involved in this incident, correct?
Yes.
Okay. A couple different jurisdictions of police.
Yes.
Police went to apartment number 7, right, and ended up getting those people out of the apartment, right?
Yes.
Police followed the Buick that Mr. Stevens was in for some period of time down to the gas station and ended up getting those people out of the Buick, right?
Yes.
And you recovered a gun.
Yes.
Okay, well, not you personally, but a gun was recovered.
Yes.
That you would later say, yeah, that looks like the gun that, you know, that kid had, that he pointed it
I
at.
was personally involved in the recovery.
Okay,
Yes, sir.
all right. It was a bucket or something like that, right?
Yes.
Let's see what else is. Now, first you can, Judge.
You may, sir.
No, states,
58, is it? No.
it's 2A. That was Madam Prosecutor, 2A?
Yes, sir, it's in 3, is it just 2A or 2A?
Is it 2A and 3A, sir?
Yeah,
Yes, sir.
You don't allow one.
Yeah, it's 2A and 3A.
All right, thank you.
Okay.
This gun, right?
Yes.
Found in this bucket.
Yes.
Okay. So, a little question or two about descriptions. The person who was in the car, who got out of the car that you referenced, was wearing black.
Yes.
Black do-rag or something like that?
Yes.
Black shirt or hoodie or something like that?
Basically all black.
Okay. Trontavia Stevens is a guy, he has a whole lot of hair, all right, like a,
I have no idea.
you don't remember?
No, sir.
All right. All right. At the time that this incident occurred back in 2013, you had been an officer at APD for how long?
I got hired November 14th, 2006.
Okay. All right. By that time, you had received what I think I heard you say was some training in regards to gangs and gang recognition and stuff like that, right?
Yes.
All right. You were trained and you were told that if there's an incident that occurs and you believe it to be gang-related or anything like that, that you indicate that on the police report.
Probably.
Okay. You didn't indicate that anywhere on this police report that there was any sort of gang involvement in this case, did you?
No.
All right. If you thought that there was some sort of gang offense committed,
Objection calls for speculation.
I'll stand this if you want. You can rephrase, sir.
you didn't charge him with any gang offense.
No, sir.
You didn't charge anybody with any gang offense on that day, right?
Correct.
All right. All right. 10 seconds if you don't mind, Judge.
Not a problem, sir.
Maybe a little more. I think I heard you say earlier, or did I hear you say earlier, that one of the things that they were looking for in apartment 7 were keys to the stolen vehicle.
Yes, sir.
Weren't any keys found, right?
No.
Nowhere, anywhere on the premises, on location, outside, in the car, in the blue car, nowhere, no keys found.
Correct.
Okay. That's all I got. Thank you.
Any further examination?
Yes, sir.
Yeah, go ahead, Mr. Matthews.
Captain Fetz, good afternoon, sir.
Good afternoon.
And just so that I'm clear, no time after you completed your report did you offer a supplemental report indicating that you observed gang signs?
Correct.
No further questions. Thank you.
Ms. D. Williams, anything? All right, Mr. Shard, anything? Ms. Westmoreland, anything?
No, Your Honor.
Mr. Weinstein, anything?
No, Your Honor.
All right, any further redirect, madam?
Yes, Your Honor, just briefly. Captain Pettis?
Yes.
I'm not going to keep you here much longer, but you were asked on cross-examination specifically whether or not you made any arrests of Mr. Stevens or took out any warrants on Mr. Stevens for the hijacking of the motor vehicle that you were investigating. Do you remember being asked by that?
I do.
By Mr. Adams, that question?
Yes, ma'am.
So, beyond receiving a report of a located stolen vehicle, did you have any facts about what had happened in Noonan
No, ma'am.
as it related to that vehicle? And so you were also asked, or you stated in your report, when you stated in your report about the person driving the stolen vehicle and where they went, notwithstanding where they went, you didn't find, according to your answer with Mr. Adams, you didn't find the keys inside the apartment where they went?
No, ma'am.
And the people who exited the apartment, Mr. Stevens was one of those people?
Yes.
The same one that threw the gun?
Jackson to the lead.
Sustained.
Was that the same person that threw the gun?
Yes.
Did Mr. Stevens run from uniformed officers?
No, ma'am.
When he was running or leaving and he discarded that gun, who was after him?
Nobody.
How did you all then encounter him?
We circled the apartment complex again in an effort to see where he was going and what he was doing because he ran the opposite direction that we were driving.
When you say ran, who was he running from?
I don't know.
All right. Were you all pursuing him?
No, we were going the other way. He pointed the gun, we drove the other toward the street, and he ran back toward the back of the apartment complex.
Did you said you called for backup?
Yes, ma'am.
Did backup arrive?
Not at that time, no.
How long after the backup arrived?
The time it took for us to circle the apartment complex, see Mr. Stevens re-enter the apartment complex through a hole in the fence, flag down the Buick that was driving by, get into it, go back around the apartment complex, so half of the circle back toward the street. Then they made a left, which was south on Old Hateville Road. Then a patrol car arrived, and we directed them toward the vehicle that Mr. Stevens had entered. So maybe 2 minutes. That would be my approximation.
Are there lights flashing?
No, because when the patrol car approached the Buick stopped on its own, and Mr. Stevens exited the vehicle.
Okay. Now, how often did you see people flash gang signs at you during your time as an officer?
My guess would be on more than 10 occasions.
And this is prior to this occurring.
Sustain the question.
Was this prior to your seeing Mr. Stevens and the others come out and get arrested?
Yes.
Mr. Adams asked you about not putting in your report that Mr. Stevens flashed gang signs at you. Do you remember that?
Yes.
Did you put in your report what the person who pulled the gun on you was wearing?
Can I refer to my report?
Please do.
I did not write in the report what the person who flashed the gun at me was wearing.
Oh, okay. Mr. Adams asked you about the person, the hairstyle of the person who flashed the gun at you? Did you put in your report the hairstyle of the person that you actually charged with aggravated assault was wearing?
No.
Did you put it in your report?
I don't need to. I did not describe his hairstyle.
But is it any less true that he had a hairstyle? I mean, it's something.
I sustain the question.
Did he have a hairstyle?
To my recollection, he did.
Was he wearing clothing?
He was.
Was the fact that you didn't put it in your report indicative of the idea that it didn't exist?
I sustain. Yes, it is. I sustain the question. Remember, you got him on redirect.
Does the absence of those facts in your report equate with the absence of or the existence of those facts?
It does not.
Okay. Is there any particular reason you didn't put what Mr. Stevens, who was flashing the gun at you, was wearing in your report? Any particular reason?
I did not write a description of his clothing because he was captured so quickly afterwards.
Okay.
The time wasn't great enough to account for what he was wearing in the report.
Is there any particular reason you didn't write what gang signs he was flashing at you in your report?
No, ma'am.
Okay. And is there any particular reason you didn't write his hairstyle in your report?
No, ma'am.
How are you able to remember today that the gentleman that exited that apartment came out flashing gang signs at you, and in particular that Mr. Stevens was the most aggressive one flashing the gang signs? How are you able to remember that? It's been 10 years.
I have a general recollection of the incident because this was the last investigation that I conducted as an officer before I got promoted to investigator. So it's more important, I guess, than others. As far as the question that you asked about the gang signs, I've been, since I was subpoenaed here and had to recollect this incident and read my report, I think that let me refer to my report to what I actually wrote. My answer is that when I wrote that Mr. Stevens was more aggressive than the other males, I was mentally incorporating the throwing of gang signs as a universal sign of aggression, but I didn't write it out.
And when you were asked by Mr. Adams, were you told to indicate if an incident was gang-related? You answered probably. Do you remember answering probably?
Yes.
Can you state with certainty that at that time you had been instructed to make those kind of indications on your report?
I cannot.
And did you, as a matter of course, list out every single detail of every incident that you responded to as an officer?
No.
Were you assigned to the gang unit at that time?
No.
Is the information you've given to the jury the best recollection that you have?
I sustain the question.
Yes, Your Honor.
Anything further, madam?
Do you have any particular relationship with anyone at State's table that would cause you to say anything that was not true?
No, ma'am.
That's all I have.
Anything further, Mr. Adams?
Just a little bit. All right. You're a police officer, right?
Yes, sir.
You're a captain.
Yes.
You, what you do when you're conducting an investigation affects people's lives, right?
Yes.
You arrest people and take their freedom and take them into custody, true?
Yes.
And you are charged with writing reports that reflect the truth so that someone down the road, maybe a prosecutor, can rely on that information and know if to or how to prosecute someone, right?
Yes.
That is extremely important. Would you agree with me?
Yes.
All right. And so when you write your report, and when you were writing reports back in 2013, those things were just as important then as they are today in this courtroom, right?
Yes.
Okay. And so you weren't a rookie officer back in 2013. You had been on the force for some 7 years?
Yes.
Okay. And so before coming in here to testify, whether it's today, I don't know, yesterday, last week, whenever, did you have an opportunity to sit down with the prosecutors and talk to them about your testimony and your recollection of the events of 2013? Did you do that?
Yes.
Okay, right. And you still came in here today, and this is the first time, right, that you're mentioning anything about gang signs that you saw when you were brought in here to testify in this, quote, gang case, right?
Yes.
Okay. Now, just out of curiosity, what was the gang sign?
Hold on. What's the basis for your objection?
Well, with respect to
What's the basis of your objection?
form, first time.
I'm going to overrule the objection.
Okay.
Go ahead, Mr. Adams.
Come here. What was the gang sign you saw being thrown up that day?
No idea.
No idea.
None.
Okay. But you know it was a gang sign, right?
Yes.
Okay. You said something a while ago I wanted to touch on real quick. You said that you will, quote, your words now, mentally incorporating the gang sign in describing the person as being the most aggressive. Is that what you said?
I did.
Mentally incorporating it. But you don't know what gang sign we're talking about.
No, sir.
All right. That's all I got.
All right. May we excuse... Oh, I'm sorry. Go ahead, Mr. Matthews.
So, Captain Pettis, I just want to make sure I'm clear. You described these events about this individual, Mr. Stevens, pointing a weapon at you, right? And just prior to that, you said that he had flashed these gang signs, right?
Yes.
And you agree that if a person is flashing their gang signs at you and then they point a weapon at you, that's criminal gang activity, right?
I don't agree with that.
Okay.
No.
Anything?
Charged with any criminal street gang activity, correct?
Correct.
Thank you.
Anything further on behalf of any counsel for the defendants? All right, madam, anything else?
Just briefly, when you spoke with Mr. Adams and he asked you, is this the first time that you mentioned gang activity? What did you mean him to, or what did you understand him to be when he says first time?
I took that to mean as in regards to Mr. Stevens' actions that day.
Okay. And as they relate to speaking in court or anywhere else, is there any other time you've had an opportunity to talk about what Mr. Stevens did?
Yes.
When?
A couple times this week. Today.
In a formal setting?
No, ma'am.
Okay.
Well, actually, let me. I don't know what the adjudication process was with this case. I don't know if I testified at grand jury. So I can't say with certitude that I've never spoken formally about this because I don't remember.
And when you were asked what was the gang sign by Mr. Adams, and you said no idea?
Yes, I said that.
If you're saying no idea to what was the gang sign, how are you able to testify to the jury that it was in fact a gang sign?
By the forming of the hands, by the overall gesticulation. I think that You don't need to be a police officer or be educated in what sign means what gang, and any of the gang rule handbook or any of those things to understand what a gang sign looks like when it's being postured towards you, especially considering the totality of the circumstances that I was in the moment. So I don't.
Were the signs that were being made by the individuals that came out of Apartment 7 similar in nature?
I can't answer that either. I wasn't well educated then on what the gang, what sign relates to each gang, and I'm not today either.
Okay. Were those signs that you saw signs that you had seen in similar circumstances in the past?
Yes.
Thank you. That's all that I have.
May I ask?
Yes.
Captain Betts, did you get any training at the police academy on gang?
Probably.
That's all I have.
Anything further, Ms. Adams?
No, sir.
All right, anybody else? All right, may we permanently or temporarily excuse Captain Pettis?
Your Honor, we can, at least temporarily. I don't anticipate needing him again, but I don't know how things are going to go, so we're releasing him for today.
All right, Captain Pettis, thank you for your patience with us. I'm going to temporarily excuse you as a witness, so that means you're subject to being recalled at some point in time. We'll reach out to you if we have to do that. Just remind you not to discuss your testimony with anybody except the attorneys in this case, okay?
Yes, sir.
All right, thank you, sir.
Thank you.
All right. Ms. Hilton, does that one of Ms. Weaver's documents?
It will be done.
All right, don't be trying to take the stuff now, okay? I'll watch everything. All right, okay. Ladies and gentlemen, how about some lunch?
Yes.
Yeah, resounding yes. All right, that's what I like to hear. All right, ladies and gentlemen, at this point in time, it's about 10:01. How about we come back at 2 o'clock? Is that all right? Okay, all right. Remember my admonitions I've given you. If you decide to leave your headquarters, please remember to keep your juror stickers on so everybody can notify you or identify you as a juror. Leave your notepads in your basket, and remember all the admonitions I've told you. Would it be proper for you to discuss what you heard on the stand with each other now? No. Now, come on, you need to sound better than that. I mean, that sounds kind of lame, you know? All right, no, it's not permissible for you to do that, okay? So just as a reminder, you cannot consider the case until I give you instructions on how to do so. So just as a reminder, a continuing reminder about that. Ladies and gentlemen, thank you for your patience. Enjoy your lunch. We'll see you all at 2 o'clock, okay? All right, all rise. All right, ladies and gentlemen, please be seated. Our jury has left us. Counsels, take lunch as well. I'll see you all back for 2 o'clock, okay? All right, we're in recess.
That you looked at the occupants of the Buick and decided they had not come out of number 7. Do you recall what you said in your report about the occupants of apartment number 7 as it relates to walking towards your vehicle?
No, I do not.
Would reading your report refresh your memory? And if it would not, you have to tell me so that we can take another step.
I don't think it would.
All right. The report that I have in front of me that is marked as State Exhibit 50A. Would you look at it, not for the sake of refreshing your memory, but look at it and tell me if you recognize the report, first of all.
I do recognize the report.
How do you recognize the report?
It looks like the one that I wrote on January 25th, 2013.
Okay. Now, the report that you wrote on January 24th, 5th of 2013?
Yes, ma'am.
Was that written in close proximity temporally to the time that the incident occurred?
Yes.
And is it a routine part of your responsibilities and your practice to memorialize incidents as they occur?
Yes.
And does the report that you memorialize, the incidents that you write a record of, do they accurately inside your report reflect the incidents that took place in close proximity temporally to the report?
Yes.
All right. And are these reports made during the normal course of business with the Atlanta Police Department?
Yes.
And was this report made based on the personal knowledge you had at the time that the incident occurred?
Yes.
Your Honor, under 24-803, past recollection reported the state tenders State's Exhibit 50A Alpha.
Any objection to States 50A?
One moment.
Mr. Adams.
Okay, let's take a pause in that testimony from earlier today. The trial's actually on a break. They've been dismissed for lunch, but let's bring in my two great guests right now to talk about what we've heard this morning in this trial. Joseph Scott Morgan, I'm going to start with you. This is sort of the building block testimony, I'd like to call it, where you bring in, the first law enforcement who may have been touching the case or may have made those first observations that have led to a larger investigation or an arrest. How important is this testimony for the jury early on in the case?
It is critical, and here's why. You're talking about a RICO case, and it is so layered and so dense. All of the charges that are involved, all of the components of the violations that are involved, and so you have to do this piece by piece. And it's almost, if folks at home will kind of think of it this way, you almost need a tour guide. I hate to, kind of simplify it that much, but it is so very complex. You need somebody that was actually boots on the ground that can orient you not just to the law and perhaps the violations that took place, but also the geography and kind of the complexity of that, the various locations where they made these encounters, and also the people that inhabited that area, the day-to-day routine. That's why it's important, they're talking about Zone 3 here, his connection to that. He's now a deputy commander of that particular zone in the city of Atlanta. And so that's, it goes to the heart of the case, and people begin to kind of understand it, and it unfolds before them. But, look, I know I'm preaching to the choir with you guys. RICO cases are some of the most complex cases that there are in all of criminal law.
No, absolutely. And Joseph Scott Morgan, you're going to be leaving us at the top of the hour, so I'm going to take this moment to take a quick question to you. You think it's a good start for the prosecution, yes or no?
Yes, most definitely, because you have to pave the way.
Excellent.
You have to pave the way with this as you're getting started.
Joseph Scott Morgan, thank you for joining, and stay tuned here at Law and Crime. We'll be back after this break with more live trial coverage. Okay, welcome back to Law and Crime. And the RICO trial for Young Thug is currently on their lunch break. Thug and his 5 other co-defendants are accused of participating in Young Slime Life gang. As we wait for the day 4 in court to continue, we want to take viewer questions now. So send them via social media and YouTube, and I will try to answer them here with my esteemed legal panel. And I'm joined right now by Law and Crime's legal analyst, Brian Buckmeyer, to answer your questions with me. So, Tall Glass from YouTube wants to know, with this type of case, do you think jury sequestration should have been done, especially with all the news and internet coverage? Brian, what do you think?
I would have thought so, yes. I mean, absolutely. I don't know where you can go and not hear about this case. And we're all the way up here in New York. I've got to assume it's a lot more saturated, this case, in the community that is actually hearing this case in Fulton County.
No, absolutely. Of course, jury sequestration is a big ask, and maybe they did it. Maybe they tried to do it. But here we have the jury not sequestered. So ideally, they're being shielded from all this media, including what we're doing right now, Brian. So let's go to our next question. And I have Breathe from YouTube. How was Stevens associated as a YSL gang member per se by his actions after an officer found the stolen car? Officer didn't mention in report no gang sign seen. So what do you think about that, Brian?
I'm guessing we're about to hear it, but I think it's going to be difficult because we've heard that he saw gang signs, that he's familiar with gang signs. But there could be rival gangs, there could be different gangs. If we're talking specifically YSL, I would expect him to say he made a sign like what we've seen in the photos of Young Thug or other members of the alleged YSL gang. I think any defense attorney might come up and say, well, did you see him make a Crip sign, understanding that YSL is affiliated with the Bloods? Or did you see him making probably not accurate, like a MS-13 sign? If it's a different gang, then I don't know how it's connected to this one. That might be some pushback here. Or maybe it's not even a gang sign. I don't know, but there's got to be something more.
Right, absolutely. Let's go on to our next question. It is from Luis Claudio Ferreira from YouTube. Isn't being a gang affiliated an aggravated crime? Why he didn't wrote that on his report? So I'm going to answer this one, Brian. So he didn't write it in his report, but this is the officer who is making a report investigation. When it comes to the charging of a crime, that is ultimately to the prosecutorial agency. In this case, it would be the district attorney's office in Atlanta. And whether a crime rises to an aggravated crime, there's certain factors that have to be met. Sometimes gang affiliation will satisfy that. And we really have to see at the end of this case what charges are being presented to this jury in the indictment with the RICO charges. But the officer himself wouldn't have the power to deem a charge an aggravated crime. Let's go on to another question. I have Carolyn Anderson on YouTube. Do you think the defense attorney dispelled any theory concerning one of their clients being related to the carjacking incident? Brian, I'm going to go to you on that one. What do you think?
I don't think so yet. I mean, but we're only hearing objections, right?
Right.
That would probably come in the cross-examination about what did you write in your report in terms of description? Did you actually put my client's name down? Did you believe it was someone else? Or how are you identifying this person specifically? Aside from that, they're not necessarily concerned the most with the actual crime individually itself. They're concerned with its connection overall to the gang and the RICO charges. So I think we might not just hear a separation from that individual and that crime, but the separation from that crime and the gang altogether. I think that's where the defense attorney is really going to attack this case.
Right. And it's early on. We have a long time to go in this trial to see how the defense starts attacking this evidence on cross-examination, and then ultimately the defense case, which will likely happen after the prosecution puts on all their evidence against these multiple defendants. I'm going to go on to a next question now. We have Real with Robo from YouTube. How does the carjacking support the RICO charge? Does RICO have to further the gang? How did that carjacking further the gang? So, Brian, what do you think?
I mean, that's what we're still waiting for. But yes, the carjacking has to further the power, influence, money, garnering more, not property, power and I guess real estate, so to speak, for this gang. They've got to connect that together. So it's either they carjacked for the purpose of then selling the pieces. They carjack to influence other gangs, and other people say, like, this is our territory and we're expanding. There's got to be some other connective tissue. But I think at this point, we're just laying the foundation of what the crime is, and then the prosecution, hopefully for them and for the victims they're representing, are going to further the argument and say, here's the connection between the carjacking with the overall influence of this gang.
Right, absolutely. And we have Alicia Brooks from YouTube. Does the state have enough attorneys considering the number of defense attorneys? I am not doubting the prosecutor's intelligence, but it seems a lot for 1 to 2 people. So you have the multiple defense attorneys because you have multiple defendants. Of course, the prosecutors are in court. But speaking as a former prosecutor, I can tell you there is an entire office behind you, typically as a prosecutor. And although that these prosecutors are the mouthpiece for the state of Georgia in that courtroom, they likely have an army of other assistant district attorneys, paralegals, and staff to help them behind the scenes, so to say, whereas the defense attorneys most likely have other staff members and whatnot, but you have the multiple defendants, so that equals multiple defense attorneys, all with different considerations for their clients there. So I think the prosecution probably have ample firepower, so to say, behind them back at the DA's office. All right, I'm going to go on to another question. I have DC71 from YouTube. Do judges reflect on their objection rulings at the end of the day? Because it seems he's more fair today. Brian, what do you think?
I think it's case by case and person by person, but I would lean towards yes. I think everyone in that courtroom, whether it be judge, defense attorney, or prosecutor, look at what they did that day and then try to reevaluate. Judges often have clerks as well, and I would probably argue it's not even at the end of the day. It might be at the end of the morning session. He's probably doing it now, thinking about, hey, I might have felt like I was kind of leaning one way more than the other, or maybe I felt like I was pretty middle of the road, and then continue that way. I would draw the analogy to any kind of professional referee. Sometimes you'll see the ref kind of leans to one team at the first half and then they kind of make up for it in the second half. Maybe that's what we're seeing today in contrast to the previous days.
Yeah, no, absolutely. And of course, there's going to be a ample record at the end of this trial. And if there are convictions here, you would imagine that the defense are going to be looking at that record, seeing how this judge ruled, and considering whether to take things up on appeal. All right, next question. Desi from YouTube. Why are the faces of the law enforcement officers not being shown? Brian, what do you think?
So I think we actually talked about this in the morning meeting, that there was an actual dispute that happened on social media where there seemed to be threats towards the officers. And then after that, officers, and I think not only threats, but I think their addresses were also posted on social media. And then officers started seeing people at their homes that seemed really suspect. And so I think as an extra layer of protection, what the court is doing based on that is no longer showing the officer's face for just an added protection for not only the officer or their home, but their families as well.
Right. You always want to consider the safety of the witnesses in court, and typically a judge would have that as first and foremost consideration during the course of the trial that they are presiding over. Teresa Trice on YouTube asks, in your professional opinion, does the state look bad after this witness? Teresa, I'll answer your question. I think we're pretty early on in this trial. So this witness, and Brian and I were sort of discussing off camera, he needs his recollection refreshed a lot as to the documents. So how well was this witness prepped? It is one of the first witnesses we are seeing in this trial for the prosecution. But right now, I would say with this testimony, I don't think it's really hurting the state in any way. But we have to see after this witness is cross-examined by the defense, whether his testimony still rings as credible, and then we can make that assessment. We are going to go to another question from Carolyn Anderson on YouTube. Isn't it realistic for someone in the apartment to think that someone sitting outside their apartment was casing them out? Brian, what do you think?
I think it's realistic, yeah. The question just becomes, how is either the prosecution or defense going to use that information? I'm assuming the question is about casing them out. Maybe the officers outside the officers being outside and people inside believing that the officers are casing them. Then the question becomes, Why would you believe that the officers are casing your home? Is there an innocent explanation for that? Is there a criminal explanation for that, or somewhere in between? We heard from Brian Steele, a Young Thug's attorney, describing this community and their, specifically Young Thug's, relationship with the officers. Maybe there's just a general fear of officers watching outside your home. I know as a defense attorney, we often make the correlation of no one's ever driving down the street and see lights and sirens behind them and say, oh, thank God the police are pulling me over. There's always a sense of fear or worry, regardless of who you are, as to what's about to happen. So maybe that's the case here.
Yep. Let's go to a question from P. Brian, also from YouTube. Is it proper for the state to say at the end of opening, the jury needs to do their duty and reach the only verdict that speaks the truth, guilty, implying a not guilty verdict is not the truth? It is proper for the state to argue to the jury certain opinions of what they think the evidence is going to show and what they are going to ask the jury to derive from that evidence. So in an opening statement, which is not evidence, and the judge instructs the jury that opening statements and closing arguments are not evidence, they're just arguments from the attorney, it is proper and it's typical for the prosecutor to ask the jury that at the close of the evidence, at the close of the case, that they should reach a verdict of guilty. So I think that would be a proper comment in the opening statement by the prosecution. We are going to take a quick break here at Law and Crime, but keep those questions coming. Brian and I will do our best to answer them, so stay tuned here at Law and Crime. Thanks for tuning in to Law and Crime. I'm Imran Ansari. The RICO trial for Young Thug and his fellow defendants is currently on their lunch break. And as we wait for the day forward in court to continue, we want to take some of the viewer questions from social media and YouTube. I'm going to be breaking down your questions with the help of Law and Crime legal analyst Brian Buckmeyer and Sirius XM host Mina Say What, Yona. Thank you both for being in the studio with me. So let's jump right into the questions right now. So our first question is from Twitter, and it's, did I understand it correctly that some defendants, Kendrick, Ryan, and Stillwell, are charged with RICO because the state now thinks that some of the crimes they were convicted of were in furtherance of YSL? And if so, wouldn't that be double jeopardy? All right, Brian, I'm going to throw this one to you. What do you think of that?
So two-part question. Yes, you can be convicted of a crime, for example, possession of drugs or possession of a gun, and then convicted of it, and later on you find information that say, oh, you had that gun because you were trying to intimidate a rival gang or trying to rob a liquor store or whatever it may be, and that was in furtherance of the gang. It's not double jeopardy because it's technically a different charge. Double jeopardy is being charged for the same crime twice. Right. So the gun possession and then gun possession in furtherance of a gang enterprise are two different crimes, even though they stem from the same action.
Right, absolutely. Let's go to the next question. I have AJ Taylor from YouTube. Do you think this case could have reached the federal level? Mina, what do you think?
I think they're going to try and see what happens at the state level. I mean, from my understanding, RICO cases are like of this magnitude are not really popular on the state level. I mean, we see a lot of the RICO cases coming from the federal level. So I think this case is so massive, they're going to kind of see how this plays out. And obviously, when you have a RICO case at the federal level, they have so many more resources than the state does. So I think we're going to keep an eye on this one and see how it kind of impacts overall who gets charged with RICO, and then, you know, if we see more state RICO cases, especially when it comes also with like artists, because that's a new nuance as well.
You know, absolutely. I mean, seeing a RICO case like this against Young Thug and YSL, and actually using some of the lyrics from their songs as evidence in this court, which of course is something which is controversial right now. There is that act which is going before Congress, where they are trying to nip that in the bud and prevent prosecutors from doing so. But the fact that it's being applied to a RICO case, which traditionally could be federal cases, large organized crimes, I think this is something which is going to really set precedent and see if it goes forward against other artists or things like that.
And that's where I was going to go. I think this is really groundbreaking. I feel like what we're watching. I mean, I really watch every day, and I'm like, wow, I can't believe this is happening on a state level. And I almost feel like, depending on how this goes, I would not be surprised if it starts opening up to other states and other individuals who have public personalities that have a social media or make songs and then wrap them into something RICO related. I mean, we see a lot in the music industry. There are a lot of groups. You know, they're not necessarily criminal groups, but they are groups. So I think this is something to really watch and see how it impacts overall moving forward.
Yeah. What is artistic expression and what is actual criminality? I think that's going to be a big issue here. Let's go to our next question. It is from Just Chillin' Here from Twitter.
Hi.
And Just Chillin' Here also wants to know, if this trial should end in a mistrial, do you think the state will go for a retrial given how long this trial is? Brian, what do you think?
I think, because you got to remember, there's 6 defendants here, right? So I think it depends on who gets the mistrial. I could see Young Thug getting a mistrial, and they're like, you know what? You're King Slime. We've got to go after you.
Not King Slime.
But if someone on the lower end of it, I can probably see them saying, you know what? Take a probation, plead guilty to this, and we won't retry you, because a lot of the 9 defendants who already took pleas, they're not serving jail time or a lot, if that. So I think they might forego a retrial for some of the lower end people, but for the upper end, at least in their mind, they might retry.
Yeah, no, absolutely. Let's go to the next question. We have DGG from YouTube. And the question is, how hard is RICO to prove. Mina, I'm going to get your take on that. We were talking about RICO. A RICO case, how hard is it to prove?
So I'm not an attorney. I don't know how hard it is to prove, but I do know that RICO allows you to try a whole bunch of people together, right? And all you really need to prove is conspiracy. And it can just be that one charge. But what is conspiracy? It could be, I thought about it, I was hanging around you, I knew you were doing it, and now I'm not speaking up. All of that can be being an accomplice, being a conspiracy to the crime. If you actually read the counts, a lot of it is conspiracy to commit or violate the RICO Act. So I think that because they wrapped it up in a RICO and it wasn't just separate charges, and because they're all together, I think that if they do a good job of proving their case, that YSL is in fact a criminal gang, and that the individuals on trial actually committed these crimes in furtherance of the gang, I think you can kind of just tack on conspiracy to just about anyone. And that's really what the scary part is.
Right. Well, Mina, for a non-attorney, you broke that down wonderfully. And yes, RICO cases are very hard to prove. Prosecutors, if they want to bring a RICO case, really need to step back. They need to think, do I have the evidence in order to bring a RICO case and be successful and show those predicate acts and the course of conduct in order to support ultimately a pretty hard charge to prove. So we'll see if the prosecutors are able to do that. Let's go on to our next questions, and it's about the jurors being shown yesterday. And we have Tall Glass from YouTube wants to know, if the jury was shown, do they have the right not to participate in this trial? Brian, what do you think?
So as a lawyer, when you say the right not to participate, I don't think there's an enumerated right for someone to no longer be part of a jury. A courtroom is technically an open and public forum, and so a juror can be seen. However, we do create backstops to that for safety reasons, and that's why they're not typically seen on camera, and especially cases like this. I don't think that they have a right per se to say, I no longer am going to participate. I think they can be held in contempt of court, but they can raise an issue of fear of their own safety and safety of their family. That might be enough to convince the judge who says, you know what, this is a credible threat, this is a credible fear, and we're going to take you off, maybe put on an alternate that the media has not shown as yet, and then we're going to curtail the way in which we show the jury going forward. That might be a remedy, but I wouldn't say it's as far as a right.
Right. No, yeah.
And I think the judge mentioned that, there were some security issues. I mean, yesterday, I think there was a lot of confusion. It was supposed to be like a 10-minute break, and it ended up being over an hour. And it was like, well, what's going on? I mean, they were very aware of what had happened, but the judge addressed it and said, look, we're going to continue this trial as long as no one's safety is a concern, as long as there are no security issues, we're going to continue. But they do have those alternates. But I did see a lot of people on social media calling for a mistrial because of this. It's not going to be because two jurors were seen in a blurry image, and if their safety is at risk or people have identified them, they would just replace them.
No, absolutely. So it's not necessarily a right to get off, but if the jurors vocalize that they cannot now sit in this trial, listen to the evidence with their full attention because they're so now fearful for their safety, even the attorneys may want that juror off the case and an alternate put in. Let's go on to the next question. We have Danny from YouTube. Why did Captain Pettis not want his face shown, but stated his name in open court if he's undercover? What do you think about that, Mina?
I think it's a protection thing. I mean, we saw this with the YNW Melly trial as well. It's just a protection thing. I know that we live in an age where you can find someone and where they live. And that was a lot of the conversation yesterday as well. Like, we saw someone's face, we can find their Twitter, we can find their LinkedIn. But even so, he has to, as an undercover officer, has to take the steps that he can take in order to maintain some kind of, cover or anonymity. So I think if he has that option to say, hey, I don't want my face shown, even though we do live in an age where you can pretty much find anyone, I think he should take that option.
Right. And let's go to Brian Sells from YouTube. Do you think the video of the front row jury members will have an impact beyond the short discussion about it this morning? Brian, what do you think about that?
The video, I'm confused by that question. The video of what exactly?
The front row jury members.
I guess we might have, similar to the question beforehand about us being able to see the front jury members. I'm not sure. I think it's going to be a continued conversation based on what is shown going forward. So long as no ability to identify the jurors, no credible threats. I think, as we said earlier, if a juror voices that issue and it raises to the level of them not being able to do their duty as a juror, then there's an issue. But until then, I would say keep going.
Yeah. Next question is from Real with Robo from YouTube. How is the returned stolen car the level of RICO? It didn't further anything other than the annoyance of having their car stolen. Brian, I'm going to throw that back to you.
Come on, Brian, for the win.
All the legal ones
for the win.
It's something the prosecutor's going to do. I think that's a great fact for the defense because the question becomes, if you steal a car and then it goes back to the person, do you think that King Slime is saying, hey, just go steal this thing and give it back? Like, how is that furthering the gang activity? This is, I think, something that the prosecution's got to somewhat piece together to explain this, that there's got to be some sort of communication, some sort of reason why this action would have, maybe it's a scare tactic. Maybe it's a way of saying, like, hey, if I want, I can take your car, I can take your property, and you have nothing to do with it. Maybe that's what the prosecutor argues. But other than that, this could just be a dumb kid who couldn't properly steal a car.
Yeah.
And that's some of the difficulty and the strengths of a RICO case, because you could say stealing a car could be an act of just showing power and intimidation, and that furthers the gang activity. Or you could say stealing a car is just an idiot kid who couldn't steal a car and there's no connection to the gang. It really comes into the interpretation of what the jury views.
I also think a lot of these members have criminal records already, so it's hard to really distinguish what is crime just for the sake of crime and what's the crime on behalf of the alleged gang. And I think that's really what the issue is. I mean, that could have been a crime that, he was just committing because he commits crimes, right? He wants a car. But it's like, how do you prove? And that's really what it is. You have to prove that this was on behalf of the gang. And that's where they really got to bring it full circle when it comes to some of the things that they're outlining in this particular case.
No, absolutely. They got to connect the dots and be able to show and prove that RICO charge beyond a reasonable doubt against these defendants. We're going to take a quick break here at Law and Crime. When we come back, more questions from you. So stay tuned. Okay, welcome back to Law and Crime. Right now, we are covering the trial of rapper Young Thug. They're on their lunch break, but it gives us the opportunity to correspond with you and take your questions on YouTube and social media and do our best here to answer those questions. And to help me do that, we have Law and Crime legal analyst Brian Buckmeyer here in the studio, and also SiriusXM host Mina, say what? Yona, I did it again. Thank you both for being here. Okay, so let's go to the first question. And we have Lee Shore 89 from YouTube. The question is, how much time is Jeffery facing, Young Thug? And how long will this trial take? Mina, I'm going to throw that question to you.
So the length of the trial is like one of those questions where people are betting at this point, because initially they said 2 to 3 months, but then that got expanded to 6 months. But now we're seeing how everything is playing out. I mean, Young Thug's attorneys and the other defendants' attorneys as well, they're constantly interrupting, constantly challenging, to the point where the judge is like, I'm done with the objections. So it's like, it's holding things up. And then you add on the fact that there are 6 defendants. So we have to go through all of their alleged crimes. And then you have all these potential witnesses, right? 400. So it's like, now I guess the estimate is a year. That seems like such a long time, doesn't it?
It's an incredible amount of time. You know, you have multiple defendants, as you say, Mina. You have a complex case. We've talked about that. RICO cases are traditionally complex cases. But that's ultimately going to, the judge is going to somehow need to step in and rein it in and make sure that this trial proceeds in an organized and timely fashion. Because you have to think about those jurors also.
Right.
Of course, there's trials that are long, but those jurors all have families, they have their lives. And of course, you want the evidence put before that jury in a complete way. You need the defendant and the defense to be able to really have their chance to attack the evidence or put on their case. But again, the jurors, and the judge will have to have that in mind and that in consideration in order to move the case. So it's not going on for months and months and months.
And I also think there's the nuance of the gang, right? The gang related stuff. I don't think many people are gang experts, right? So even me just watching it, I'm taking all these notes about things that I wasn't really privy to, right? So it's like you have that part of it, laying the foundation for the culture that they're operating in, and then explaining that to the jury. And when it comes to the question of how long potentially Young Thug could serve, it really depends on if they find him guilty and what counts he's guilty of, because he's up for 8 counts. Some of them are like, robbery. No, not the robbery. He has the arms counts. He has the controlled substance counts, and then also the conspiracy for RICO. So it really depends on if they find him guilty, what they find them guilty of, and then what his sentence will be if there is any.
Right, absolutely. And let's go on to Royal Team from YouTube. How is this relevant to the 6 defendants on trial right now? So with that question, I'm not sure exactly what Royal Team is referring to in terms of what is relevant. But let's just talk about the evidence in general. How about that? Brian, what do you think? I would imagine it would be the relevance of Officer Pettis's testimony right now. How is that bearing on these 6 defendants?
Well, so this is a conspiracy to violate the RICO Act as well as gang activity ties. I think both of those top charges have a 5 to 20 year sentence. And so what you have to do is understand how the gang works, right? What does the gang do? Right. Is this a gang where you're selling Girl Scout cookies outside of stores and restaurants? No, it's a gang that involves stealing, robbing, shooting. And so I think what's happening here is we're understanding the breadth of what this gang does, and then they'll start implanting, okay, so this is what they do, this is how they extend their power, this is how they extend their territory, and now this is how these players participate in it. Because as Mina said, like, not everyone's a gang expert. I mean, you and I hang out with gang members as a part of our job, right? And we have an understanding of how those people operate, and how those that I would say not subculture because they're less than, but subculture because they're separate from the main culture that everyone understands. Not everyone understands that. No, not everyone knows what it means to be like the 3 of us are 550. People be like, what does that mean? Well, we're neutral. We're not, I don't know if you're neutral. I know he's neutral. But I'm neutral. We're not gang affiliated. We're 550, right? That's something that people have to be explained to, understand, and know what it means. And like if I throw up a sign, like, I'm not gonna throw up a sign because I don't need RICO coming after me.
Right.
Like, what does it mean? Like, how does this work? What does this handshake mean? We understand that because of our clients. They need to bring that down and then show how they all work into that environment.
Yeah.
Right. And they have to somewhat do their best to keep it simple, right? Because too much complexity, you start losing the jury. You got to put it all out there. But there's so many nuances and facets to gang culture and whatnot that they have to keep it in a manner that is palatable to that jury and it's easily understood.
Right.
Let's go on to the next question. Mike D from YouTube. What do you think about the rap lyrics being used in this RICO trial? And Mina, we talked about that a little.
Yeah.
Let's talk about that.
It's definitely a debate. I actually did a Twitter poll, and I guess the question is, how are you using the rap lyrics? So in this trial, they're using it conditionally, right? If you're using rap lyrics solely as evidence, I think that is just a violation of amendments and people's right to create music, create art, right? But that's not what's happening here in this particular case. Now, we haven't seen all the evidence, but they claim that they have instances and events that happened, right, that somehow are identical to some of the lyrics in these raps. So you don't have just rap lyrics as evidence. You actually have, according to them, evidence of crimes, the people who committed these crimes, and they can tie the people who committed these crimes to Young Thug, and then he's kind of talking about these crimes specifically in his raps. That's very, very different than just saying, hey, I heard you say I shot the sheriff. I'm going to arrest you and indict you on RICO. It's not the same thing. And according to the Twitter poll that I took on my personal page, people said yes to using the rap lyrics as long as it's not the main source of evidence. It's almost like the cherry on top, right? You need to be able to prove your case without the rap lyric, but if you have the rap lyric, it's kind of like, we also have this as well.
Right. So it was
I want to jump on
and confession.
Yeah, I want to jump on this one. So I have similar feelings, but slightly different, not only with this case, but in general. We probably both represented people where rap lyrics were used, right? And my thing is always, there needs to be a standard in which you can connect that rap lyric to actual events. I would say preponderance of the evidence, 51%, right? And I've had clients go on and say, hey, I spotted you in the corner here and I shot at your mama and now your mama don't talk no more. And we have video of you shooting that person's mama on that corner. I'd be like, bro, why are you rapping about this? Like,
right.
That don't make no sense.
This is a confession.
That is a confession, and that's being used. But some of the lyrics here I have a problem with. If you use, for example, what they're doing, in one of their major cases, they have the rap lyric from Anybody with Young Thug featuring Nicki Minaj, where he says, I didn't kill anybody, but I got something to do with that body.
Yep.
I'm a general, right? They're trying to attach that now to the death of Donovan Thomas Jr. That because he purchased a vehicle, a rental car that 5 other people used to allegedly go and kill Donovan Thomas, that's him confessing to it. To me, that is far too broad. That song came out in 2018. The shooting happened in 2015. We don't know whether Young Thug himself wrote that lyric, whether there was a collaboration between him and Nicki Minaj, whether there are ghostwriters, whether or not he's actually talking about that incident. It's too far removed for you to use that for a murder, in my mind.
I want to kind of pick your brain on that, right? So there's another lyric where allegedly, YSL shot at the other rapper, YFN Lucci's mom's house, right? So there's no evidence, according to Thug's attorney, that he had anything to do with that. But he raps about shooting someone's mom's house, and now they don't mention me. How about a lyric like that?
Did she mention him beforehand? Did she stop mentioning Young Thug specifically after? Because that would be the corroborative information. If before the shooting, she was specifically saying Young Thug, Young Thug, Young Thug, Young Thug, then got shot at and then stopped talking about Young Thug, I would say use the lyric. But if you don't have any information outside of that lyric to corroborate what is being said there and done, what are we doing here?
Yeah, I mean, we could be debating this all day.
Right.
It's in fact going in front of Congress. This is something that people are advocating against. So it's really relevant, and I think this is going to be a benchmark case. Right? If there's convictions coming from this, if there are convictions that are stemming from these lyrics that were used as evidence in this trial, and there's appeals, this could be something that will percolate up on the appellate level, and we'll all be watching.
Yeah.
Right? So, all right, let's get one more question in before we take a break here. I have AJ Taylor from YouTube. The first witness couldn't identify anyone, and the second witness doesn't know anything about gangs. How is the state going to move forward from here? So, Brian, what do you think?
So in law school, I'm not sure if you had the same metaphor that was used. An argument is basically a bundle of sticks, right? One individual stick is easy to break, while a bundle makes it harder to do so. And so the witnesses don't provide the whole bundle in itself. They provide just one stick at a time. So you got to wait for the witnesses to come up, because this witness might say, hey, I saw some gang activity on this block. I can't identify who they are. Leave it there. The next witness might come and bring another stick to that bundle, and then another stick, and then another witness, and another witness. So yes, this witness, I see reasonable doubt. I don't see anyone guilty of anything. But you gotta wait for all the witnesses to put their own individual stick into that bundle to see how strong it is. And then it's the defense's opportunity to come up there and say, you know what, they're pretty flimsy, and break it, or it's too strong to be broken.
Yeah, ultimately, at the end of the day, the prosecution will put those sticks before the jury, and let's see if they are able to build a case against Young Thug and the other YSL defendants. We're going to take a quick break here at Law and Crime. When we come back, more Q&A with your questions. Keep them coming. Stay tuned. welcome back to Law and Crime, where we're covering the trial of young thug in Atlanta, Georgia. Right now, they are on a lunch break, so we are taking your questions and doing our best to answer them here in the studio at Law and Crime. With me is Brian Buckmeyer and Mina Say What, Yona. I'm going to get back right into these questions from our viewers. This one is pretty interesting. It's from Fillmore Tim from YouTube. In a RICO case, if convicted, do all defendants get time, or is it possible that some will and some won't, or is everyone automatically guilty? I'm going to get both your take on this. I'll start with Brian. What about you? What do you think?
It's the second one. It's the one where some can and some can't. It all depends on your participation, the evidence against you, and how you further that. If the three of us all have an idea of coming together and committing a crime and whatever, and even if you take steps towards it, but I went and ratted you two out, and it's like, yo, these guys are going to go rob a bank, and I would probably less likely be convicted, while you two would be, and you probably get more jail time than say what.
I also want to point out there's different counts here, right? Yeah. So that's going to obviously influence guilty, not guilty, and then obviously the jail time. I mean, Thug has 8. One of the defendants has 19 counts, 9 counts, 7 counts. 1 count, 8 counts. All of that is going to vary. You know, how many counts do you get found guilty or not guilty of? And then do you serve jail time? Right. The degree of the count, right? Is it the gun charge? Is it the controlled substance charge? Or is it the conspiracy to violate the RICO Act? All that's going to take into account.
Yeah, no, absolutely. Each defendant, individual charges, individual counts, all need to be found individually guilty of those particular charges that each defendant is charged with. Let's go on to the next question. And Brian, this is something directed at you.
You have a fan.
Yeah, one of your many fans out there.
Is that you, Mom?
Hi, Mom.
It is, if your mom has the handle Real with Robo.
Oh.
Yes, so this question is from Real with Robo from YouTube. The car being returned, a person getting jailed doesn't seem to further a gang's fear or influence. How is the prosecution doing, in your opinion, Brian?
Well, thank you first for the directed question. Right now, I'm kind of just sitting and waiting. I'm looking for them to connect the dots. To me, the dots are a little bit far apart, but I don't see the whole picture. The taking of the car, I think like you, I think probably like the jury as well, they're scratching their head and saying, what is this? Now, could we find evidence that the YSL gang just randomly goes and steals vehicles just to perpetuate fear amongst the community, and those vehicles get found elsewhere, and that this is just their hallmark? Yeah, and that could be RICO. Or could this be a one-off? I don't know. This, unfortunately, is a point where we got to just see and wait.
Right. Next question is from JC from YouTube, and Mina, I'll get your take on this. Will the 400 witnesses exhaust the jurors and go against the DA in the end? What do you think?
I think it's a bit much, and it's a lot of information. It's a lot of different people. I think it is exhausting. I've read the full list, and I don't understand why it wasn't narrowed down. I mean, are we seriously thinking that, you can call all of these 400 people? That was really one of my questions. I know they narrowed it down from 700, but I do think it would be exhausting. And I get it. They want to keep things on the table depending on how the trial goes. And, you call people that you see fit. But I do think having too many witnesses is just exhausting. And it's kind of like you keep beating the horse. And it's not engaging. And after a while, it's almost detrimental if the jury starts tuning out, because it's just too many people saying too many things.
Yeah, no, absolutely. You want the jurors to be very attentive, listening to the evidence. And of course, I always say trial is dynamic and unfolds as the testimony and evidence is put forth in that courtroom. Maybe they'll whittle down that list of 400. Maybe they'll decide, all right, we don't need that witness. But you always want to keep the jurors' attention and keep the evidence sort of streamlined before that jury. Let's go on to the next question. I have a question from Michael L. coming in from YouTube. Many of the defendants took plea deals, so their charges/case had been adjudicated. Why aren't the terms of the plea deal then made public since their case is over? Brian, what do you make of that?
So I think some of the terms are, like for example, we know that some of the 9 have to testify against any person who comes forward. Those I think would probably be seen in the sentencing of those individuals. But if you're talking about like behind closed doors deals, like we often see CIs or CSs, confidential informants and confidential sources, those deals as to how they got to the ultimate plea deal, those probably won't be seen, and that's often for safety reasons. A lot of people are in gangs that supposedly kill rival gang members and supposedly kill snitches. I think a lot of that is kept just to keep those people who took plea deals safe, as well as their families.
Yeah, absolutely.
Yeah, and I think some of the stuff is public. Like I have it in my notes. Certain people made written statements that can be used in court. Certain people will be called to testify, and we already know they might invoke the fifth already, is information that's been made public. And some other people have said, I mean, one of the co-founders that got a plea deal, he said, I will agree to testify truthfully, and these are the things that I will testify to. So some of it is public, and then some of it is not.
Yeah, no, absolutely. And Mina, I'm going to throw the next question to you. The officer who testified today this morning indicated several times he doesn't even know gang signs. He didn't place noted gang signs in the report. How is he relative to this RICO charge? We have about a minute to break. What do you think?
Well, we'll see how they tie it all in. You know, I think a lot of it is they have to piece together what they have. And we had someone that was very versed in gang culture and gang life and really broke it down. This witness is giving it from another perspective. So I think all of it is part of that pie that they're trying to serve.
Absolutely. Brian, what do you think?
Yeah, I think it's exactly the pie that they're trying to serve. They're going to get pieces together. The only question is it going to be a pie that the jury wants?
Right.
Or not?
Is it apple? Is it pumpkin?
Yeah. I think we're going to see a lot more in terms of expert witnesses talking about gang signs and whatnot. But whether this, ultimately the credibility of this witness is in question, we'll see. Mina, Brian, thank you for joining me and our viewers and answering their questions. You both were excellent. So we are going to be taking a quick break here at Law and Crime. And when we come back, we will be still maybe taking your questions. We're waiting to see when the court's going to come back from lunch, but we're going to be covering continuing our trial coverage of the Young Thug trial in Atlanta, Georgia. And again, thank you, Brian and Mina, for joining. And thank you for your questions out there. Stay tuned here at Law and Crime. Okay, welcome back to our live analysis here on Law and Crime. I'm Imran Ansari. Thanks for joining us. Today is day 4 of the racketeering trial against famed rapper Young Thug and 5 other co-defendants. Young Thug, whose real name is Jeffery Williams, is on trial for participation in a criminal street gang called Young Slime Life. Williams was arrested in May of 2022 along with 27 others, but many of which has since been severed from this case or taken plea deals. Gunna, another well-known rapper, took a plea deal in this case and might be called to testify later in this trial. The prosecution theorizes that the gang, YSL, is responsible for violent crimes such as murders and carjackings. However, the defense team claims that YSL is simply the name of Young Thug's record label. The Atlanta courtroom is currently on their lunch break, so we are taking viewer questions right now from YouTube and social media. With that, I'll introduce my legal panel for this hour and get right into those questions. I have former prosecutor Bridget Williams and Nima Rahmani, and they are here with me. And I'm going to start with you, Bridget. Now, Siobhan Mears from YouTube asks this question. Could the state still offer Jeffery, Young Thug, a deal during trial? What do you think, Bridget?
They can if they choose to. I doubt if they will. The state has the opportunity to present the defendant with a plea offer at any time if they choose to do so. However, once we get this far along into a jury trial, unless something comes up that is completely harmful and just destroys their case, but he has multiple counts here, multiple charges. I do not foresee them coming up with with a plea offer here. Sometimes, let's say if it leads to maybe a mistrial or something like that, then maybe the state may come along and offer something else. But at this time, I do not foresee them coming up with a plea offer for Young Thug.
You know, absolutely. They are in the middle of trial, of course. Now all bets may be off the table, and they're going to be going forward trying to get that conviction. Nima, I'm going to throw you the next question. It is from AJ Taylor, also from YouTube. Do you think the state's case is weaker than most other cases you've seen? You're a former prosecutor. What do you think?
Well, it's certainly not the strongest case, but there's plenty of evidence here. You have cooperating defendants. And at the end of the day, whenever you're dealing with a RICO conspiracy, the exposure is high because each individual defendant, they're on the hook for all the acts in furtherance of the conspiracy. So you have cooperating witnesses. That's what I call them as a prosecutor. The defense, of course, will call them rats. But generally speaking, before you bring a case like this, you're going to want to make sure that you have a lot of corroborating evidence to support any type of RICO indictment. You don't want to rely on the cooperator testimony alone. So you're going to have surveillance. You're going to have wiretaps. You're going to have evidence that's not impeachable like cooperator testimony.
You know, absolutely. And Bridget, the next question. Do you think that trying all these cases together make it harder on the jury? And that is a question from Reggie with the Seeds Jones on YouTube. What do you think?
Okay. Well, that's a good question, Reggie. What I'll say first is starting out is that it doesn't necessarily make it harder because the evidence is all pretty much going to be the same. That's the reason why they're trying this case all together. So it's an opportunity for the court to just do all of the evidence at one time and one trial instead of repeating this long drawn out process for each and every defendant. So that's the reason why they do that. Try to save taxpayer money, try to save time, right? Because this is projected to be about a 6-month case with over 400 witnesses on the state side alone. We don't know how many witnesses the defense counsel is planning to bring. But with that, what the court is trying to do is save some time, save some energy, so that way all the cases are tried at one time.
Yeah, Nima, the next question from Monumental TV from YouTube is sort of a practical question about the jury, given the fact that this may be a long trial. And the question is, if this trial goes a year, how will the jury be properly compensated in order to afford their bills in place of their jobs?
They're not going to be compensated, or they're going to be compensated very, very little. So whenever you have a long cause case like this, one that's going to go for months, usually what the court will do is an additional voir dire or jury selection for hardships. So anyone that gets up there and says, look, I have a financial hardship, I have a job, I have kids, they're going to be excused. Now, normally those types of hardships aren't grounds to get off a shorter trial, but in a case like this, it absolutely is. So the judge already weeded all those people out. So most of the jurors here, obviously, or folks that have told the court that they don't have a financial or other problem for sitting on a case that is going to last months and months and months.
Right. And Craig Lugay from YouTube asks, what is the likelihood that this trial goes to mistrial due to the jury being seen and social media posts? Bridget, what do you think about that question? What do you think that answer should be?
Well, we don't know what the jurors have seen yet, right? And we can only project or think maybe they have seen some things. I mean, it's widely all over the media at this time, but we don't know what these jurors have seen. And so saying that we think that it may be grounds for a mistrial, I think it may be overreaching at this time. We don't know yet. There may be other grounds for a mistrial. We just have to continue to watch the case and as it unfolds. Like you said, we have such a long time. This is just the first witness that we are on today. And so as the case continues, we'll be looking for different ways that may give grounds for a mistrial. I'm sure defense counsel is looking for it every single second. So we just continue just to watch the case as it unfolds.
Yeah, and Nima, the next question is on a topic we've been discussing heavily today in regards to this trial. The first question, is this a good case for the Supreme Court in terms of using music lyrics, and what constitutes freedom of speech? And that is a question from Danny on YouTube. Nima, what do you think?
No, it's a great question, and it's something that may end up at either the state Supreme Court or even the U.S. Supreme Court, because you're dealing with the First Amendment issue. So, of course, the First Amendment protects someone for being prosecuted for their speech. Now, that's not what's happening here. And the reason prosecutors were able to get it in is not prosecuted because of the speech, but evidence of an admission that applies to the case. So I want folks who are watching along kind of understand the distinction, right? You can't be prosecuted for your speech. That's the First Amendment issue. But if you say something that is potential evidence, that's an admission of a party opponent. So it's a rule of evidence, and that's why it's coming in. And the judge made a ruling that some of these statements are directly related to the alleged murder. And that's why they're coming in as evidence, but the defendants aren't being prosecuted because of it.
Right. And a related question from Mike D on YouTube, Bridget, do you think that all types of music should be used in court of law and not just rap music?
Of course, if you are going to use one, you can't, distinguish against the other. You should be able to bring in all types of music. But going back to the other panelist comment, it only comes in when we are specifically saying that this is evidence of a crime that was committed, and that's the only time. Anything else is just circumstantial, and maybe an overreach at that time. So the state is saying that these rap lyrics or any lyrics that were done are in fact evidence of a crime that was committed, not necessarily just, it's a lyric that's coming in. No, it is specifically evidence. And so that's why they're asking for it to be brought in.
Right. And another related question from Gray Mustang on YouTube. There's no date, place, person, or time mentioned in the lyrics. So how would they know who the lyrics are about? Nima, I'll pivot back to you.
Hey, Imran, this is a question of weight, not admissibility, right? So, look, the jurors can say that the rap lyrics have nothing to do with the case. They're free to reject any evidence they think is unreliable. But admissibility is a different question. Admissibility, the judge needs to rule, does this evidence even come in? Can the jurors consider it? So the jurors can reject it because it's not reliable, but it is admissible for the evidentiary reasons that we discussed.
Right. And T. Marie from YouTube asks, the defense stated Jeffery makes millions and doesn't have time to run the YSL gang, but wouldn't it make sense that his millionaire status would be a good cover-up to be a kingpin? Bridget, what do you think about that question?
Ooh, that's a loaded question there. I'm going to say, well, it brings back to what does the jury think, right? And so it's the defense counsel's job to present all of the evidence that he has in order to say, well, this may or may not be true. And this may be something else for the jury to consider. And so it is the jury who is the trier of fact, they are the ones who can say, well, that holds significant weight. That seems like it may be true. We don't think so on this other fact over here. And so they are the ones who are going to be the ones who make the decisions on if that is true or not. And if it holds enough weight to allow for a conviction in this matter. So that's what we're really looking for.
Right. And Nima, the next question to you, Craig Lugay from YouTube asks, is Rappa going to be a part of this trial in any capacity? What do you think about that?
I think he is, and it's just a guess, and this is why. Because I've seen it with Fonnie Willis's other case, the big one, of course, being the Donald Trump election fraud case. When she pleads out a defendant, she wants them to cooperate. So whenever you're dealing with a criminal organization, or at least an alleged one that we're dealing with here, you want folks in that organization to turn on the head of the organization. And of course, the prosecution's theory is that is Young Thug. So I think Gunna is going to have to testify in exchange for the deal that he got.
Right. And we do know that his attorney said if he is called to testify, and the state does have the right and ability to call him as a witness, he may be taking the fifth or pleading the fifth during that testimony. But it all remains to be seen. And we want you to stick with us as we go forward with our coverage and our Q&A right now with you. We're going to take a quick break here in Law and Crime. But when we come back, more Q&A as we wait for the trial to come back live in court. So stay tuned. Welcome back to Law and Crime. We are covering the young thug YSL trial in Atlanta, Georgia. The court is still down for its lunch break. It gives us the opportunity to take your questions on YouTube and social media and answer them here in the studio and at Law and Crime. Helping me to do that are my two great guests right now. I have former prosecutors Bridget Williams and Nima Rahmani. So, Nima, I'm going to start with you with this next question. How does the other defendants pleading guilty affect the jury's decision? And this is coming from Create Your World on YouTube. What do you think about that?
Well, the jurors aren't going to know about the other defendants who pled guilty unless they testify and they're cross-examined on that basis. So each case and each individual defendant needs to be judged on its own merit. So it's not like they're either all guilty or either all not guilty. It's not evidence in the case. And the only reason it does potentially become evidence is if it's used for cross-examination of a witness, but it's not going to come into the case otherwise.
Yeah, and Bridget, Real from Robo on YouTube wants to know, how is the prosecution going to not only prove RICO, but also the other charges in the case? Isn't that a bit much?
It is a bit much, but we are waiting to see how they go about doing that. It's one of the reasons why this case is so long and expected to be such a long, drawn-out trial is because, one, RICO is such it's a difficult case to prove. It is a lot of complexities. There are a lot of moving parts. The state has quite a few things that they have to bring in to show that there was an organized crime that may have had multiple people involved that led to profit and issues throughout this entire gang or conspiracy amongst all these people, right? So they have quite a bit on their shoulders to do here. Now, is it impossible? No, they can definitely do that, but that's the reason why they have so many witnesses lined up. That's why they have so many gang experts lined up. That's why they project that this case will take so long. So I do think that it's a lot for them to do, but they have to make sure that they go throughout this evidence, present it all clearly to the jury, so that way they are all following along and not missing any of the evidence, because it's going to be a long trial. So we're just waiting to see how that unfolds.
Right. And Nima, I'm going to ask you the next question. It comes from Craig Lugay on YouTube. What are the pros and the cons of all defendants being tried at the same time?
So there's advantages and there's disadvantages. I mean, the advantage is, as a prosecutor, you're going to dirty everyone up, and that you get all the evidence in one case. You know, you don't have to have multiple trials, right? Because if you do that, then you can have finger pointing and say, listen, it wasn't me, it was this individual. But that's a lot harder to do right together. The disadvantage is we're seeing here on Law and Crime. I mean, there are more than a dozen defendants, dozen defense attorneys. Each witness examination is taking days. So it really slows the process down. Logistically, it becomes a little bit unwieldy. And it's a challenge to have an individual witness have to testify and be cross-examined multiple times.
Yeah, and the next question actually goes to some of the testimony we heard from Captain Pettis this morning. And Bridget, I'll ask you this question. It's from Go Get a Dash from YouTube. Do you think that by the DA allowing the captain to add later that he saw gang signs in his testimony showed some type of negative intent on the DA behalf to the jurors?
I don't think it showed any type of negative issues from the state. I think that what it did was it allows for the state is just trying to make sure that they bring in all testimony and make sure that they are asking all the questions that they need to from this particular witness and making sure that they cover all their bases. Like I said, this is a very complex case. And so they have the opportunity to recall any witnesses that they choose to at any time, right? But while this witness is on the stand, we're going to make sure that we clarify whatever we need to do, and we're going to ask them all the questions that we need to.
Right. Nima, we talked about Gunna possibly testifying at this trial and pleading the fifth if he is called to the stand. Our next question from Teresa Coakley from YouTube asks, if someone pleads the fifth, isn't it like saying, yeah, you're right, you're hiding things, not being forthcoming?
Well, potentially, right? So a constitutional right can't be used against a criminal defendant. You can't argue that, well, you're guilty, that's why you exercise your right to remain silent. That's completely unconstitutional, and it's prosecutorial misconduct. Now, the question is, if Gunner wants to assert his Fifth Amendment privilege, does the state immunize him from any additional criminal liability? So the state says, listen, you've already pled, I want to give you immunity for your testimony. Then guess what? There is no right to remain silent, and you do have to testify, because guess what? There's no criminal exposure there. So it's going to be interesting to see, does the state really need his testimony? Obviously, let's be honest, Gunner got a lot of flack on traditional and social media for agreeing to plead in this case. So he may not want to testify at a very public trial, because there's going to be a lot of blowback there.
Right, absolutely. And the next question is from Brianna Lynn from YouTube. And Bridget, I'll ask you this question. Brianna Lynn wants to know, will this trial affect the YSL record label?
That's not one that we know of, but as far as this particular case goes, we're looking to see here, is this individual going to be convicted of a charge or not, convicted of racketeering? I think there's also murder cases as well. There are several charges against Young Thug and then all the other defendants. And so this particular case, this trial is to decide if they are guilty or not guilty, right? And so we don't know if that's going to affect their rap label or not, but that's something that maybe can be discussed or determined after the trial is over, once we decide, or once the jury decides if they are guilty or not guilty.
Yeah, and there's a question from Siobhan Mears from YouTube, and I'm going to answer this question.
All present, come forward.
All right, ladies and gentlemen, please be seated. All right, Ms. Love, call your next witness, please, madam.
Thank you, Your Honor. We are calling Sergeant Heeb, H-E-E-B.
All right.
Act 3.
All right, summon, is he in, what's his, is he an officer?
Sergeant.
Sergeant? Okay, all right. Do we have the issue of this witness as well?
Yes.
Ladies and gentlemen of the media, please don't take any photographs or video of this particular witness. Thank you. right, Sergeant Heap, good afternoon, sir.
All right, sir.
Sir, if you could please approach the witness stand. Once you get there, if you would turn and face Sergeant Ingram, be sworn as a witness before you sit down, please.
Raise your right hand. You swear affirm testimony you give the truth, the whole truth, and nothing but the truth.
I swear.
I see. State your first and last name. Spell first and last name for the court. Speak loud into the mic.
Jonathan Heeb, JONATHANHEEB.
Good afternoon, Sergeant.
Yes, ma'am.
All right. Sergeant Heath, let's start by introducing yourself to the jury. Would you tell the jury where it is that you currently work?
Currently, I am assigned to Zone 3 Crime Suppression Unit as a supervisor.
Now, you said Zone 3.
In the Atlanta Police Department, I'm sorry.
All right. How long have you worked Zone 3 in Atlanta at the Atlanta Police Department?
I have been assigned there since September 1st, 2022, so a little over a year.
Is this the only time that you have worked in Zone 3?
No, I've done a lot of work in Zone 3. This is the first time I've been assigned directly to specifically Zone 3, but I've done a lot of work in Zone 3 throughout my career.
Now, what are some of your responsibilities as a supervisor in Zone 3?
Right now, I supervise the crime suppression unit, so our main focus, beyond my normal admin stuff and timekeeping duties, I supervise a small team of individuals, officers that focus primarily on the high crime areas within the zone.
Prior to working as a supervisor with Zone 3, what were you assigned to do?
I've had several assignments throughout my career. I started in Zone 6, then I went to the Apex unit. I worked in Vice. I was in narcotics. I was assigned as a task force officer to a federal task force for several years. Worked in the drug interdiction unit at the airport for a few more, and then got promoted to sergeant, where I've been in Zone 3 ever since.
So let's start back at your first assignment with the APD. When was that? When were you first?
I was assigned to Zone 6 Evening Watch around May or June of 2008, I believe.
All right. And what was your responsibility there?
Just a normal patrolman, answer 911 calls.
How long did you stay with Zone 6 before you were moved to Apex?
Probably less, I think, probably less than 3 years. I was probably right at 3 years, maybe a little bit more. I can't exactly remember, but just a couple years, three years, give or take.
And with Apex, what areas of the city were you responsible for monitoring?
With Apex, we had the whole city. We focused on the higher crime areas of the city, but we had reign over the whole city.
And run that back by me. Did you tell us what Apex stood for?
Apex stood for Atlanta Proactive Enforcement and Interdiction Unit.
When did you leave Apex?
I left Apex around 2014.
So on August the 23rd of 2013, where were you assigned?
I was assigned to the Apex unit.
Now, have you been certified as a law enforcement officer by the Peace Officer Standards and Training Council of Georgia?
Yes, ma'am, I have.
Have you remained certified by post during your entire law enforcement career?
I have.
Prior to starting with the Atlanta Police Department in Zone 6, what was your background?
I came out of the Army.
How long did you serve in the Army?
4 years.
And did you leave under honorable circumstances?
I did.
And thank you for that service.
Yes, ma'am.
So going back to August the 23rd of 2013, with Apex, did you work with any other agencies that were responsible for law enforcement besides the Atlanta Police Department?
We did. We worked with several. Predominantly, the one we worked with the most was going to be the Department of Corrections, Probation, and Parole's officers.
Why is that?
Because typically the type of violators that we were pursuing regularly were repeat offenders And we had a lot of greater access to them and their whereabouts and their kind of historical information through probation and parole, obviously because they're so, they interact so frequently.
Was there any particular probation or Department of Corrections officer that you worked with at Apex during this time?
The one that we work with most consistently was Officer Viverito.
Okay. On August the 23rd of 2013, were you working with Officer Viverito?
I was.
Would you tell the jury what it was that you were doing in that capacity?
So that we were doing a detail to try to apprehend some individuals that had outstanding warrants from probation violation warrants. So outstanding warrants from probation.
Were you looking for any particular individuals, or were you looking for random people with probation warrants?
That day, at that particular time, our primary focus was looking for and apprehending Shannon Stillwell.
How did you go about trying to locate Shannon Stillwell to apprehend him on probation warrant?
So we, Viverito and I and another officer went into a plain vehicle, an undercover vehicle, dressed in plain clothes, to try to go to areas where Officer Viverito kind of knew that he may be, that he frequented. And so we went out to look for him, and our main objective was to locate him, positively ID him, and call in the uniform takedown units to try to apprehend him.
And did you end up in the Mechanicsville area of Fulton County?
We did, 322 Glen.
Now, how long at that time had you worked the Mechanicsville area, or been working around?
We spent quite a bit of time in that area throughout my time in Apex. So I had spent, the majority of my time in Apex was spent in that area. I couldn't give you an exact number of months, but several months, to the point where we kind of knew where the hot spots were, if you want to call it that.
Was there any significance to 322 Glen? By that I mean, was it an apartment complex or something else?
322 Glen is known as the Green Store. It's a convenience store, it's green, and that is where it was notorious for illicit activity, primarily narcotic sales.
Was any and everybody able to sell narcotics at the Green Store based on your experiences with Apex during that time?
Not just anybody, no.
Then who was able to sell narcotics at the Green Store?